All right, the time is 6:32. We now call to order the Historic Town of Eatonville Community Redevelopment Agency Board meeting. Krista, can we verify quorum?
Yes. Director Thomas?
Here.
Director Jordan?
Here.
Director Mack?
Here.
Director Williams is
Present.
And then we have Chair Prince.
Present. We stand
Board member Prince.
for a quick. We can stand for a moment of silence and pledge of allegiance. And the pledge of allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have a presentation tonight. I will yield to Attorney Jackson.
Board members, good evening, members of the board. I just wanted to report to you all the outcome from the directive that was given by this board on this past Monday at an emergency meeting. One of the first things that I do want to point out is that, again, there have been questions with regards to whether or not the meeting on Monday was a properly attended and properly set meeting, because at that particular time, board members, Washington and board member Randolph attended this meeting. And so the question was whether or not their resignation from the council meant that they could not attend the TOPA board meeting. I believe that Florida statute was very clear. Chapter 163.356 indicated that board members shall continue to serve until their seats are filled by their successor. I also saw that there was an email from the former mayor of Eatonville, who basically said that Mr. Johnson would remain terminated, so he was not returned to his status of employment as his board directed. The vehicle that is a CRA vehicle, it's not a town vehicle, but the CRA vehicle still has not been returned to Mr. Johnson. He has not had his emails restored to him so that he can do his work as the executive director of the Community Redevelopment Agency. And the email from the former mayor stated to the HR director of the town, please be aware that an OAG opinion regarding the legitimacy of the vote taken on March 16, 2026 gathering and suspension and termination authority of the chair mayor is being requested by Attorney Shepard until opinion is received and disseminated to the administration. Mr. Johnson remains terminated. So what I did was I actually went and I found an attorney general opinion. So Mr. Shepard does not have to go and seek an attorney general opinion as to whether or not the members who attended could attend that meeting. Pursuant to an attorney general opinion, which is AOG 77-05, so that means that it's well established. It states that the resigned municipal officer may continue to serve until the vacancy of the unexpired term of his office is filled in accordance with procedures provided in the municipal charter. However, in this particular instance, you have something that's much stronger than the charter. You have Florida law. And Florida law dictates that the members, who at that time, board member Washington, board member Randolph, were to serve, not may serve, but shall serve until their successors were appointed and qualified. This particular AOG opinion is related to a commissioner in Riviera Beach. That commissioner had resigned his seat in much the same way that board members Washington and Randolph had done, so that they could run for, he had run for a county commission seat. So he resigned his city commission seat so that he could run for a county commission seat. He lost his election. And so when he resigned, his resignation was to be effective the date that he was supposed to be sworn in for office, similar to board member Randolph and board member Washington. So the question was, could he continue to serve even though he lost the election and his seat was still open? And the attorney general, the same body that Attorney Shepard said that he was going to seek an opinion from, has already weighed in and said that the resigned member could continue to serve until their office had been filled, that vacancy had been filled in accordance with their charter, which their charter was similar to state law that said that he served until that seat was filled. So the question of, number one, in the mayor's email, the former mayor's email, was that a legitimate meeting? If we go off of the body that Attorney Shepherd was going to seek guidance from, the answer is yes. That's the same answer that I gave on Monday. Consistent with Florida law, it's the same exact answer that I've given, but that had to be questioned. The other question of whether or not the mayor had the authority to terminate the TOCA executive director found another attorney general opinion. Since my opinion was not sufficient for the former mayor or Attorney Shepherd, I went to the opinion of the Attorney General, and there is a February 24, 2017 informal opinion from the Attorney General's office. And just to go to the more pertinent parts, and I actually have copies of each one of those opinions for the board tonight so that you can review those things. But what it basically states here is that particular council has said that per the charter, the mayor had the authority to appoint the executive director. Same as what we're kind of hearing here, except it's kind of reversed, that the mayor had the authority to terminate the executive director. Now, we know that that's not true because of the independent nature of this board. And the Attorney General's office has spoken to that and said that this board has confirmed that this board is independent, separate and aside from the town. And more specifically, and as I indicated, I want to be very clear about this because these are opinions that I have given without having to waste the council, or excuse me, the board's time or money and researching this and fighting with the town's attorney. But it says the powers of the CRA governing body or board and limitations thereof are prescribed by the statute that do not arise from the city's charter. In other words, the powers of this board is statutory and have nothing to do with the town's charter. It also says it would be beyond the authority of the city to alter the powers and duties of the CRA members or to allow the mayor's veto power over city legislation to be insinuated into the mayor's role as a member of the governing board of the CRA. In other words, the mayor cannot interject him or herself into the operations of the CRA because, as it states here, this is an independent, legally separate body from the town. It further says, where the legislature has prescribed the manner in which something is to be done, it by implication prohibits it being accomplished in any other manner. In other words, when the Florida statute says that you have to do something a certain way, you don't step over that and say, I have a charter that says differently. You follow Florida law. And Florida law dictates that this is an independent body, an independent board from the council, and should be treated as such. And so it says that while that particular council, while you posit that the mayor's authority under the city charter to hire or appoint department heads provides the authority for the appointment of the CRA's executive director as discussed above, the city's charter does not control the actions of the CRA. That is an Attorney General's opinion. And the reason why I went to this is because this is what Attorney Shepherd said that he was going to seek for this board. And if we were going to have to wait for Attorney Shepherd to seek an opinion from the board, Mr. Johnson, under the direction of the mayor, improperly so, would have had to wait a year or more before the Attorney General would have weighed in to say exactly what I've said from the beginning when Mr. Johnson was improperly suspended and then improperly terminated by this mayor by bylaws, by town policies and procedures, and by Florida law. So the question of whether or not the former mayor should have followed this board's directive, the answer is yes. The mayor should not have disregarded this board's direction to return Mr. Johnson back to his current position as the executive director of this agency. Now, as you look around, Mr. Johnson is not here today. Mr. Johnson is not here today because it is still being maintained that Mr. Johnson is an employee of the town and not of the TOCA. He's not here today because Mr. Johnson has been trespassed from the building. He's not permitted to come into his office to work with his staff because the former mayor has put in a dictate that he has been fired, and to no fault of the staff that works here who is following the former mayor's directive, as well as the direction of the town attorney in telling them that he is a town employee and that the meeting that was conducted on Monday was improper, and that the mayor had the authority to suspend and terminate Mr. Johnson, they're operating off of direction of the town's attorney, which again, his directions pursuant to the very body that he was seeking direction from is 100% absolutely false. Now, he did provide, he did provide board member Critton, I'll say it that way. He did provide board member Critton with some opinion where he wanted to support his position, still to this day, despite being provided OAG opinions that refute what he has stated, but despite being provided with Florida law that refute what he says, he's still maintaining to this very day that Mr. Johnson is an employee of the town and that he has been properly suspended and terminated by the former mayor, which again is 100% false. I read through the memo that he provided, and I sat there and I looked through some of the items that he provided to support his position. One talked about dual office holding. That has nothing to do with the executive director. It has nothing to do with the resigning of the individuals who sat here properly at this meeting pursuant to Florida law and were able to provide a directive to the board on behalf of the board that Mr. Johnson be returned to his full status as an employee. The next thing that he provided, I could not find it. I could not find what he provided. I sat with board member Critton and I even showed her, when you type in the case that I showed you, 77-0, AGO 77-05, I can pull it up and it comes up. When you type in what he provided, 89-06, 7 cases come up, nothing on point. If you're going to provide opinions and if you're going to take away someone's right to work and to be employed, please provide accurate information. Because the individuals, the former mayor, to her credit, relied on the town's attorney. That's who she opted to listen to. And I don't fault her for doing that, but he was wrong. Anything that you bring me and show me up until this point that he has done, he is wrong. And I hate being in this position. And I've told this to anyone that will listen. I've told it to the CAO. I've told it to board member Critton. I've told it to the executive director who is currently, he's actually here at the meeting online because he was afraid that he would be arrested when he came into this building. I've told it to board member Thomas. I hate being in this position. This is a proud town where the town and the CRA should not be battling and fighting against each other. In full disclosure, I shared with Mr. Johnson. Mr. Johnson, despite the fact that I discount my bills, because everybody knows here that I don't charge this agency for every single thing that I do. You all know that. Despite me cutting my bill and giving discounts on my bill to this agency this month alone is going to be $10,000. $10,000 because I have to fight with the town attorney to do what's right for the employee of this agency. $10,000 that this agency now has to waste on a legal opinion that should have been followed from day one. But the other part that I pointed out is, if I'm charging $10,000, what is Attorney Shepard charging? How much is this town and this agency going to expend on legal expenses on a fight that never should have taken place? When the law is clear, and I have been consistent and clear from the beginning, that on March 13, 2026, when the mayor of Eatonville at that time sent the police officers to Mr. Johnson's house to serve him with suspension papers, that suspension was not valid. How much time and money will this town have to space, or this CRA agency have to spend or expend, when on March 17th or 16th, the mayor of the town of Eatonville sent the police to Mr. Johnson's house again to take a vehicle that did not belong to the town but belonged to the CRA and serve Mr. Johnson with termination papers, even though she did not have the authority of this board to do so. This is a fight that this board should have never been in. This is a fight that the town attorney should have stood down on and allowed what went down to move forward in the appropriate fashion, and he did not. And as odd as this may sound, I do not fault Mayor Gardner. I don't. She followed what she thought was sound legal advice. And she may stand up here tonight, or she may come and give a statement and to support her position even more, but I've given you case law, I've given you statutes, I've given you everything that you need to show that what was done to Mr. Johnson was inappropriate, and that the board's decision on March 16th, 2016 was the appropriate decision, and the appropriate individuals who were supposed to be at that meeting were here. Now, aside from that, even after that occurred, because I wish I could stop and say that that's the last thing that I received was an email saying that Mr. Johnson was still terminated. I then received emails from Mr. Johnson where he was then telling me that he was being harassed and intimidated by the HR staff of the town. They sent emails throughout the entire town employee system announcing that Mr. Johnson was terminated. Mr. Johnson, again, is not an employee of the town. Mr. Johnson has not been terminated by this board. In fact, this board has asked that Mr. Johnson be restored back to his full employment status, and that any negative reports or any negative evaluations be removed or expunged from his file. I sent a follow-up email to the mayor on the 17th of March saying that you are not in compliance with what this board has asked for. I did not hear a word. I did not hear a word from the former mayor. I did not hear a word from Attorney Shepard. But I still hear, even to this day, that the position is being maintained without a single piece of credible evidence, a single piece of credible supporting evidence that Mr. Johnson is an employee of the town of Eatonville. This board has weighed in, and this board has been very clear about the status of Mr. Johnson, and that he is an employee of the town of Eatonville's Community Redevelopment Agency. Even after I sent that, I had to send emails to the HR staff, to the HR department, HR director for the town of Eatonville, asking her to not send any more emails saying that Mr. Johnson was terminated. Also had to send messages because he was sent a grievance policy for the town of Eatonville, and I had to send an email saying he is not an employee of the town of Eatonville, and so he should not have to adhere to a grievance policy. But even more so, there has been a determination by the TOCRA board, who is his employer, that he is an employee. So why are you continuing to do this? And I, unfortunately, on behalf of this board, to protect this board and to insulate an employee of this board who may have a legal action against the town as well as against the TOCRA, I had to insulate that employee by asking them to no longer send him any emails harassing him or intimidating him by telling him that he's fired. That's what I had to do, not for Mr. Johnson, because Mr. Johnson knows full well that I do not represent him. And I've been very clear about that. He understands that. But what I do represent and who I do represent is this board. And if I have to insulate an employee who's being intimidated as an employee of this board to keep this board from being subject to a lawsuit because it's complicit with the harassment and intimidation of an employee who was wrongfully terminated, then I did what I had to do to step in and say, if you have any other communications, you send them to me as the general counsel of the agency on behalf of an employee who has now told me that he is being harassed. Mr. Johnson can send that to you by email because his emails have been disabled. So we stand here today with clear language from an OAG opinion with regards to the resign to run law that indicates that the individuals that sat here at this meeting, again, board members of Washington, board members Randolph, sat here appropriately. Attorney Shepard disagrees, despite the fact that the OAG, where he was going to seek an opinion, states otherwise. I understand he got an opinion from a supervisor of elections from somewhere. Supervisor of elections does not render advisory opinions that have any weight, in my opinion and in my view. I will share with you also that this opinion, with regards to the right to run or resign to run law, was actually crafted by a person by the name of Patricia Gleason. I know it's Pat Gleason. The reason why I know is because when I was at the Attorney General's office, I actually had some very interesting run-ins with Ms. Gleason. Because when I would have to prosecute cases on behalf of the Attorney General's office, one of the things that came up was public records requests. And so my position was, as a litigation attorney, I didn't want everything about a case to come out unless and until it was absolutely time to do so. So Pat Gleason and I would have tumbles and we would have disagreements. So I know Pat Gleason, and I know that she's very thorough in what she does. And when she says that the resigning commissioner could sit until their seat was filled, I have respect for this lady. I have respect for this agency because I was a trial lawyer for this agency. So I have respect for this agency. And Mr. Shepard did not provide me with any documentation from an agency that he wanted to seek an opinion from that would refute or go against anything that has been provided to this board by myself. The other thing that I looked at is I looked at an Office of Inspector General report that actually came from Hollandale Beach. And in that report, it talked about how the CRA was overstepping its bounds by the city, and the mayor wanted to interject itself into the workings of the CRA. This is what I'm trying to protect this board from. This is what I'm trying to protect this board from. When I sit here and I say that this is an independent agency that has been statutorily created to operate independent and separate from the town, and that if the mayor does something in her capacity as mayor, it does not hold water, this is why I say that. This board does not deserve to be a part of any investigations for any unnecessary reasons, and that would most certainly have been unnecessary. So the purpose of my presentation is to advise this board that the former mayor did not adhere to this board's wishes. The purpose of my presentation tonight is to let you know that Mr. Johnson is still considered to be fired by the town of Eatonville, although he is not a town of Eatonville employee. He's still considered to be fired. The purpose of my presentation tonight is to tell you that Mr. Johnson is still unable to access his emails, although this board gave clear direction that he was to receive and be returned to his full employment status and should be given access to his emails so that he can conduct the business of this agency, which is now almost a week past due. The purpose of me sitting here is to let you know that because of the actions of the town against an individual who is a protected individual as with veterans preference, that this agency may be at risk for having some type of action taken against it for the wrongful termination or the purported wrongful termination of Mr. Johnson, who is not an employee of the town, but it's been spread around in emails sent out across the town that he's been fired when he has not. The purpose of our meeting tonight is to let you know that the vehicle that belongs to the CRA has been taken by the town of Eatonville, commandeered by the town of Eatonville. A vehicle that does not belong to the town is now taken away and has not been returned to the CRA director, which this agency directed that it should be done. The purpose of me giving this presentation tonight is to tell you that Mr. Johnson's employees who work under his direction are fearful of their own jobs and their own position. Purpose of my presentation tonight is to ask that this board reassert and reaffirm that Mr. Johnson is in fact an employee of the town of Eatonville's Community Redevelopment Agency, and that this board's wishes, desires, and directive is respected by the town of Eatonville, and that he is returned back to his employment status immediately, if not soon. I'm available for any questions.
One question. What is the Attorney General opinion law, or is it just an opinion?
The Attorney General's opinion is an advisory opinion. What the Attorney General's opinion does in the face of there being no case law on an issue is it provides guidance as to how those things will be decided. The reason why you don't see litigation in this issue is because people understand that what's being done should not be done. The only other thing that happens at this point is you get OAG opinions or you get people coming to shut down your CRA. So although the Attorney General's opinion is not binding law, it is an advisory opinion. It is one that carries a great deal of weight. But I also use the Attorney General's opinion because it is the agency that Attorney Shepard was going to seek an opinion himself from. And if this is what the agency that he was going to seek an opinion from himself, then he too should respect what that agency has stated.
Okay, so an opinion is an opinion like we all have.
Yes, sir.
So basically, it's really not law, but it's just their opinion. So my other question would be is about the resignations. So what was the purpose of the people putting in that I resign as of this date? So my question is they say they resign at this date at 12:01. That means that's the date that they resign. If they had a said, I resign this date effective this time, that would have, so that's an argument that can be questionable.
Yes.
So basically they resigned at 12:01 when it came that day. They didn't say I resigned 12:01 this time at the end of business. I know what you said, the law is said. So they should have been directed to say that. So with them not saying that, then their resignation was 12:01.
So I looked at this issue, not just from best practices. I also looked at it from the standpoint of how courts calculate time periods. And the way that the courts calculate time periods is that it goes to the actual end of that day. So if someone says, I resign on, unless they specify a time, and the importance of it, if they specified a time, then it would have been with that specific time that the resignation took effect. If they do not do it for that particular time, then it is that entire day until the close of business, the last bit of business that's due for that day. So if the last bit of business is 5 p.m. on the 16th, then that's the effective time of their resignation, not at 12:01. As soon as 12:01 is, it's at the end of the business day on the date of that resignation.
I get that, but still, this is my opinion now. Is because they did not say I resign effective end of business on this day. Then they resigned at 12:01 when it turned that date that they say they resigned. So that would be an opinion that would be, you might say that, I'm saying this one might say that, but that their paperwork should have said that. I think so, and that's just my.
But the other thing too is that's why the law is very clear. And that's why we have to go back to what the statutory provision says.
Mhm.
And what the statutory provision says, that's very clear, and this is law, is that the members, that the councilman, or the commissioners, how it states it, shall continue to serve until their successor has been qualified and appointed. So based on that, based off of the black letter of the law, they serve in that seat until their replacement, their successor, has been qualified and appointed. That appointment did not happen until the 17th. That's when the qualification and the appointment of their successor would have occurred. So even in light of the resignation, and the Attorney General's opinion speaks to that, so when you talk about an opinion, if an opinion is nothing more than just words, then yes, I agree with this opinion. Their opinions actually is backed up by statutory law, by black letter law. So while it may just be viewed as just their opinion is backed up by law. And when you go to the law specifically states that the individuals, that the commissioners shall serve until their successors are appointed and qualified. And it also notes that the evidence of that appointment is when the clerk of courts has filed that certified appointment, and that will be evident of their appointment. So until those things happen, technically, I'm not going to tell you because that's on the town side. I'm not going to tell you the town side. I'm going to tell you this side. So technically, although they have resigned, they were still able to serve until such time that their successors have been appointed.
Give me that law.
163, 35. 1 second. I vacillate between 356 and 357. I've been looking at both of those here recently. And I'll read it directly.
So is there Attorney General opinion on that?
But that was the opinion.
No, I'm talking about on that time.
No, yeah,
That's what that is?
Their opinion is the person continues to serve until their successor is appointed. That's the Attorney General's opinion, and that's the law. And so the law says, if we go to 163. So yeah, so it's 163, 357. So what it states here So it's 356, I apologize. Okay, so what it states here is that each commissioner shall, and the word shall in the law is a very specific term. That means that you have to do. There's no wiggle room. If it was must or may, that's something different. But this says that each commissioner shall hold office until his or her successor has been appointed and has qualified. A certificate of the appointment or reappointment of any commissioner shall be filed with the clerk of the county or municipality, and such certificate is conclusive evidence of the due and proper appointment of such commissioners. And so again, it says, each commissioner shall hold office until the successor has been appointed and qualified. And the Attorney General's opinion, yes, it is an opinion, but it follows what the statutory provision is. And they say that based on that statutory provision, that a person, even if they resign from office, that they hold that office until such time that their time has expired, or that they follow whatever the replacement, the procedures to replace a vacancy is by charter. But in this particular case, you have something much stronger than charter. You have Florida law.
Okay, it says appointed and qualified.
Yes, ma'am.
So what is the purpose of the supervisor of election qualifying us that we won that position? And that the same thing, so we were qualified. That,
Well, my understanding is that the elections are certified by resolution of the council. If that is not the understanding of the town, then that's on the town side. My understanding is that that is the certification by the town. It's by resolutions of the council.
all right.
Yes, sir.
Yes, first of all, thank you, for your professionalism and just the knowledge that you've, displayed here this evening, just as well as you did it on Monday. I know we're sitting up here with a new board now. My recommendation would be, just to, nip everything in the bud. We got a quorum tonight. And I would like to put a motion on the floor to do the same thing we did Monday by reinstating Mr. Johnson back to his position. That way we won't have an argument about if the particular people that was here Monday were able to be here or not. We got a quorum tonight. So that will justify whether they vote up or down that he's reinstated or not reinstated. But you know, I do apologize for taking him through what we're going through. I think he's not an employee of the town. And the only way that he can be terminated is through this board. And that's why I'm not in favor of being a director, because there's too much biasness that go on and get sent up on this board. I would rather just be a legislator on the council side. And that's why we had the independent board, which is something that I suggested last time when we had the independent board, and it worked out quite fine. And it just take all the biases out of it. You know, that way we ain't gotta sit here and argue about who's the vice mayor, who's the chair. You know, which is something that we've already indicated anyway, that the mayor should always be the chair, the vice mayor should always be the vice chair. But to eliminate that, I think we should create another independent board while we don't have to sit up here in the midst of all this that's going on right now, because it's just too much biasness. I need to worry about legislating. That's my job. I'm a legislator before I'm anything. I'm a board member now. I don't really like the idea of being a board member because it's just too much smoke in the air when you're dealing with town business. And another thing too, I'm not in favor of interlocal agreements. I said that from the beginning. I'm one of the ones that was opposed to that. When I left office last time, it wasn't interlocal agreements. When I came back, it worked. And that's why we're in the position that we're in now, because it's so complex, but people not really having an understanding of how this goes. And of course, the Attorney General is an outlaw, we know that, but it's bound to be effective though. You know what I'm saying? Going through the thing that I've gone through legally, dealing with Attorney General, opinions and things of that nature. That's what they use in courts. You're an attorney, you're a trial attorney. And the way you displayed everything makes perfect sense. So I say that to say this right here. Being that we got a lot of people that are questioning whether former Randolph Washington was qualified to sit in these seats and make the recommendation that they did with approving for Mr. Johnson to come back. We got a quorum tonight, okay? We got a quorum tonight. So let's move forward with doing the same thing we did Monday, to reinstate Mr. Johnson back to his duties, give him his vehicle back and everything else that qualifies him to do his job. I don't see any, problem with that, especially with us as a board sitting up here. We got a job to do. And the only way that Mr. Johnson can be fired, and anybody that knows this, is by this board. And then I think what I'm doing also is protecting the integrity of this board, this town, and the former mayor, for that sake. And I know a lot of times you may feel like, the right of feelings on the sleeve, for whatever reason, you're having a vendetta about an individual. Listen, it's a lot of people that you're not gonna get along with or like, per se, in your job or whatever. It happens every day, but that don't make it right for you to just, go about firing someone because you feel like you can. Ain't no different than dealing with your kids. You know what I'm saying? If you sit here and just chastise your kids to a point of no return instead of talking to them first, right? Giving them points on what not to do, it's just not justifiable. You know what I'm saying? And what happened to Miss Johnson, I would never want to see it happen to anybody, especially, the people that work for this town, because I don't think it's right, it's not fair. And then you're gonna open up litigation that could really cause us to go into 286s that we don't want, which is in this room right here. And it can consist of a lot. I know a lot of people are sitting up here that don't really know how government works, but I'm telling you, man, this is a matter that we don't want to deal with, especially when it comes to legal litigations against.
Director, we have a motion on the floor.
No. That's what I'm gonna push. That's what I'm gonna move forward to do.
I do have. Attorney Jackson, I have talked to you many times and I appreciate your word, but I'm not questioning anything. I'm questioning myself because I don't understand and I have the right to ask you that. So my other question would be, is that I did ask the policy procedures, which I just got it at 342 or something like that. But at the time, I was not on council, but I clearly remember during that interview, it was stated to Mr. Johnson, and I did request for all of the interviews, all the recordings, so give me time to go back and review. But I do remember Mr. Johnson saying, and the HR director saying, you are employee of the town. He said he understood that, but I'm gonna go back, because if I'm wrong, I'll come back and correct myself. But I do remember that, so I'm gonna go back and listen to that. So I'm not against anything, but I want to know from me. I don't want to make a decision just off of what everybody is saying. And as a new board member, I would prefer that we table this until you really give me the chance to review this and listen to this. And if I'm wrong, I'll come back and say so. If I'm not, I'm gonna give you the exact time that it was said on this recording. So, and if it is, and these are just my questions, at what point did he not become an employee of the town if he knew this is what he was going to be because it was stated to him? But like I said, I remember hearing that. I remember him it was addressed to him. So I do not think we should vote on it. I think we should table it, at least give the new board members, this new board, time to review it. If you want a copy of the recording, everything is public record. Let's go back and listen to it and make sure it's right. I'm not knocking Ms. Gardner. I'm not knocking you. I'm not knocking anyone. I want to know and I want to be sure before I put this vote. So that's just my
I was
opinion.
actually still speaking and,
That's
no
fine.
disrespect to you, board member,
You're right.
Thomas, but, with that being said, I just want to kind of go over a few things and then I'm gonna open it up for other board members to speak on it. Listen, according to the attorney, which is Attorney Shepherd, who is the town council, right? And he is over all other boards within the town, which is Preservation Board, Board of Adjustment, Code Enforcement, Planning and Zoning, just as well as another one. It's 5 boards that he's over, but he's not over the CRE board. This is an independent board that boards itself. We govern ourselves. This is an independent board. There's a great separation that people don't need, that people need to understand that they don't understand. And that's why one of the reasons it's gotta, listen, it's more important with some of the items that we got on here now as far as the lease agreement that we're gonna move forward with. I'm definitely in favor of that because I don't feel like CRA is almost like mixing water and oil. Even though it shouldn't be that way, but it's almost like mixing water and oil together because it's two entities. You know what I'm saying? You got one over here, which is the CRA, and then you got the town. Okay, you can have the town, but you can't have the town without, you can't have the CRA without the town. Okay, let's establish that. And I'm in hopes that we could do this lease agreement to have that great separation. But like I stated before, and we're gonna put a motion on the floor with the pleasure of chair supporting this, is that we move forward with reinstating Mike Johnson back to his duties of everything. The pay that he's already missed, the truck that they took unlawfully, because if you ask me personally, it's theft. Because it doesn't belong to the town. That's theft. You do not own CRA belongings. And if you go and take it without permission, it's theft. And those are other things that could be inclusive with the litigations. If we do move forward with having legal litigation put against us. Like I said before, I'm protecting the integrity of this board, but most importantly, this town, especially the taxpayers. So I think we need to be very astute on how we do things and very mindful before making irrational decisions. Okay, that's why I think very long and hard about making decisions while I'm sitting up here, because I don't only make decisions for myself, I make decisions for this town. And I gotta make sure I'm making the best educated decisions before moving forward with doing something that will come and bite me. It'll come and bite me. And we gotta protect the employees of the CRA as well. How fair, how unfair is that? So, you know, and I know everybody here got a job, to not know if you got a job the next day. You know what I'm saying? It's almost like you didn't do the crime, but you got to take the ride to jail. And then judge look at it and say, this is a bunch of crap, and they throw it out. But you had to take that ride though. You had to go through the scar of just going to jail. And that's what it seems like. You know what I'm saying? Someone's being punished for something that they didn't do wrong. And like Attorney Jackson said, to the defense of former Mayor Gardner, she just went about legal. She went about, she trusted her legal counsel to give her the direction that she needed as a mayor. And I know how tough it is to be a mayor. I do. You know what I'm saying? Because I haven't been one, but I can just have the mind thought. You know what I'm saying? Just like the current mayor now. It's gonna be a lot of crazy decisions that we're gonna have to make. But I think it's gonna be inclusive with this board right here, as well as the council. And I can't speak on that, but I'm speaking on the board right now. We got to make sure that we're really in great communication, man, before making these irrational decisions that can come and bite us. And this right here could perhaps come and bite us if this motion don't pass with reinstating Mr. Johnson back to his duties. So as of now, I want to put a motion on the floor to do exactly what I said on Monday. And of course, you know the language, Mr. Jackson, and if you can help me out with filling that rhetoric language to fulfill the need of that, I would just appreciate it.
Before I do that, Mac, I do want to address one comment that was made by Board Member Thomas, where she was talking about in the minutes that there was conversations about Mr. Johnson being a town employee and the HR director saying he was a town employee. And so she said, when did that change? It changed the moment the bylaws were entered. And the bylaws dictates that the executive director is an employee of the TOPR and not the town. That's when it changed. You can say a lot of things on the record, just like everything that I just said may be on the record, but it doesn't change anything about a formal action that's taken. And the formal action that was actually taken was when the bylaws were put together over a period of, I want to say we started in October of 2024 and we finished in March of 2025. And at the end of that period, in those bylaws, it states in section 3.4, I want to say of the bylaws, is that the executive director is appointed and employed by the TOPR. That's when the change happened in the bylaws, which the bylaws about the language that anyone said in those discussions mean nothing. It's like if you go and you purchase a car and you all talk about what you're going to buy the car for, and then they give you a contract and you sign the contract and you bought the car for $5,000 more than what you talked about. Doesn't matter because that contract, your bylaws, is what's law. And so those discussions, those conversations, those negotiations were just that. And what this board has to go by is not verbiage in minutes of meetings, but in the bylaws that have been signed and ratified by this board. So I just wanted to hopefully give some solace as to when that happened, when that changed.
All right, and with that being said, I know I had a motion on the floor, Ms. Thomas. I don't know you're speaking.
Zach, if you could hold that motion, there's actually a agenda item that kind of addresses exactly what you're asking. We can save that so we can finish discussion and then we can circle back to that if it's okay with you.
I do understand that, but even as a citizen, I asked for a copy of the bylaws, asked for a copy of this and a copy that I never got it. So now that I'm up here, I still haven't got it, but you're asking me to vote on, I understand that you're telling me this. I want to read it for myself and see it, and if I have a question, then I answer you. But that's my opinion. That's what I want to do. So I'm good.
You heard this.
Yes, I do have something. I know, in our meeting that we had, on Monday, we all, basically, agreed to have him reinstated, and it was not done. What is gonna happen differently, let's say if we were to vote up or down and we say that, hey, we wanna have him reinstated again? Who is going to make sure that that directive is carried out? That's the problem that I have. We did this already, right?
Right.
And what we did, it should have been adhered to, but it was not. All right, so that's the issue that I have. We already did this.
Right.
Okay, but no one is adhering to what we, the board, said that we wanted. And this is a concern of mine that we are respected as the board of the Historic Town of Eatonville, first and foremost. And the decisions that we make here should be adhered to.
Right.
So who does that responsibility fall to? I don't know that we should be doing this all over again for it still to just lay on deaf ears. I don't think that I don't want to do that anymore. I want what we decided on Monday,
I agree.
right?
Yeah.
If that's what the board decided, then let's go with that.
Yeah, I agree.
I don't think we should have to go through that. And that's about respecting us as the board.
Right.
That's my thought.
Now, with that being said, Board Member Clinton, I know you're the mayor now, and I don't speak on that because you're not in the mayoral spot at this particular time, but you are the chair of this board. And with the recommendation, and I know it's been a pretty unique situation in terms of how we transition, but we're here now in the moment. And being that we respectfully made a motion on Monday to approve the reinstatement, but it was not justified in doing so. How would you handle this matter as the chair?
Before I respond to your question, I want to give everybody on this board an opportunity to respond to Attorney Jackson's presentation. Board Member Williams, do you have any additional comments other than what you said on Monday? No comment. Thank you. If that's the case, then I'll go ahead and respond, and then I will entertain your question if that's okay. I attended that meeting on Monday as well. I did not vote because the bylaw states you cannot vote by proxy. If I had voted, it would not be to bring Director Johnson back. I also want to reference, and I did read Attorney Shepard's memos, and I did hear their presentation on Monday about the impugning and intervening in CRA business. I do know that he was reached out to, and that is why we got the response from him that we got in respect to former Mayor Gardner's authority to reach out to him. I very much like Director Thomas, do not hold a Juris Doctor and do not interpret the law. And I trust that in the hiring of you as the general counsel for this agency, that you would guide us in the most responsible way forward. However, because I do not hold a Juris Doctor, if a differing opinion is set before me, I have no choice but to give it some audience. That being said, there was another email that was sent out today by Attorney Shepard that we discussed with that AGO, which is AGO 89-60, that I was able to pull up after our meeting. I know we couldn't get it up when we spoke earlier. I was able to Google it, popped up under casemind.com. You can speak to the validity of that source if necessary. And his, and of course, I'm referencing Attorney Shepard's explanation of that memo, contradicts, I believe it's AGO 7705 that speaks to the ex officio status of those members and their official capacity to vote on that evening. I also circle back to comments that Ms. Thomas made, and forgive me, let me pull out my notes. The conversations that were had with this board on October 3rd, 2024 and October 17th, 2024. And if we need times, I have those too. Give this board the understanding and the impression that this individual was a town employee, specifically. At 24 minutes and 55 seconds, former Vice Chair Theo Washington stated that we did not want to move forward with a contract and that we wanted this individual to be a town employee specifically for the purpose of protecting that position and trying to make this process the least political that we could. At 54 minutes and 10 seconds, the HR director spoke to our questions and our comments. She made reference to former Executive Director Shaniqua Rose as an at-will employee that could be, to your point, terminated by the board. At 54 minutes and 27 seconds up to about 55 seconds, it was also stated by the HR director that this employee would be at will and that town policies would govern and they would be placed in that conditional offer, and they were accepted. At 56 minutes and 34 seconds, Director Mack himself said, thank God for HR for the thorough job that she had done trying to explain to us how we could move forward in the least political way possible. We wanted to protect that position from being, and if I'm not mistaken, former Mayor Gardner spoke about how we cycle through these executive directors and how every time there is an elected official change, we come right back to this conversation. And wow, what a coincidence. Day one, we're right back at this very same conversation. So it very much feels like we're having our cake and eating it too. And I'm just saying that for my opinion. Now, Attorney Jackson, I did hear you say that the ratification of these bylaws that came approximately 6 months later do state that that employment and that appointment is by this board. What I did not see in the bylaws is the ability to terminate as the board. Can you speak to that?
So the ability to terminate is in the Town of Eatonville Community Redevelopment Agency's policies and procedures, and that speaks to that.
For the agency,
For the-
not the bylaws,
So no, not bylaws.
Okay.
But the policy and procedure manuals. are-
which we just received.
Well, no, that was given out on Monday, actually.
But recently received,
Well, that was actually emailed last week when.
but not at the time of the meeting or of the ratification of the bylaws. At the time that we made the decision to bring him on, and at the time that we amended the bylaws, we didn't have a copy, and I didn't have a copy. I don't know about Director Williams or Mac. I know Director Thomas and Director Ware Jordan weren't here, but we did not have in our possession at that time those plans and policies.
So if you're asking me the question of, does the bylaws give the board the authority to hire and terminate the executive director? Where it says the board appoints and employs. If you employ someone, that means you can hire or fire them.
But does that not also give space for administration on the town side to fire if we have said that we don't want that on this board?
Absolutely not, because so what you're trying to do is you're trying to and this is what the Attorney General's opinion has warned against. What you're talking about right now is now you're saying the town can come in and take away what the CRA has put in place. That is absolutely what the law is trying to prevent and has prevented through Florida statutes.
Okay.
So if you're asking me now, through the bylaws, because it says that the TOCRA can employ the executive director, also means that the town can come in and have some control over that person? Absolutely not. That is absolutely not what it says. And the other thing too, I'm looking at this 89-6, and this talks about nepotism. This is talking about.
89-60 or 06?
89-06 is the,
89-60?
okay, you said 06.
I apologize.
Okay, I'll look it up.
Director Shepherd's, or excuse me, Attorney Shepherd's memo quotes 89-60. My apologies.
I saw it as 60, but 06, but okay.
Yeah.
Yeah, so when it's 60, I don't, okay. There we go.
I can give you, the Attorney General was Robert Butterworth.
I know Mr. Butterworth as well, yeah.
Okay.
But if you want to keep going, I just wanted to
Okay.
address that, but yeah, when you
Because-
say employee, that means that that person, the employing body or the employing agency has the ability to
Hire and fire.
Yeah,
Okay, I just wanted to clarify that. I'd like to continue with this. The vehicle that was removed from the possession of Director Johnson, if I'm not mistaken, and the council or administration could correct me if I'm wrong, should not have been there. It should have been at town hall. Or it should have been at the location of the similar vehicle. So I do understand the concern that property was removed without, so I want to acknowledge that. I do acknowledge your concern. So I think maybe we should, is it popping up? Okay,
yeah,
You
this
can-
is not on point.
okay.
So
I
this,
just wanted to-
and this is what I'm saying, if you're gonna give information, and not you, if you're gonna give information, make sure that you're not just throwing numbers out there and saying just resign, and make sure that you're reading what this says. This is talking about a county commissioner who sat on the CRA board, who no longer wanted to serve on the CRA board. He wanted to resign from the CRA board, but to continue to serve on council. The Attorney General said cannot resign from the CRA board and still serve on the council. This has nothing to do with what we're talking about.
I just want to make sure. 'cause
Yeah,
it was right.
these are the inconsistencies that I've warned against. These are the inconsistencies I warned against. This is not on point. This has nothing to do with what we're talking about.
Okay, I'll circle back. Thank you.
Yes, ma'am.
But yes, Director Mack, I did want to address your concerns. And I heard some similar concerns from Director Williams on Monday about the removal of the property. I think then this is just one thought that we should specify what our policies are as it pertains to that, just so that there is an understanding moving forward. God forbid this ever happen again, whether or not there is authority to remove said property from any individual, whether a town employee or an agency employee. Because it doesn't belong to Mr. Johnson. Even if he has the authority to use it, it is not his possession. So just to make sure that we operate respectfully, we should probably clarify that somewhere in our policies, or I don't think it's necessary to go into bylaws, but just to make sure we don't put ourselves liable for those types of actions.
I believe Mr. Johnson was assigned the vehicle by the board. And so
Assigned?
the fact that he was
Via
assigned.
resolution?
I want to say it was a resolution, but even at that, he was assigned that vehicle by the board, which means that he was handed the keys
Understood.
and told that this is the vehicle that you're assigned to. So whether by resolution or whether by acquiescence, that was a vehicle that this board authorized him to have and to use, and that vehicle was taken from him. In much the same way, if he would have taken that vehicle to downtown Orlando and someone stole it, that is his vehicle that has been taken out.
If you can get me written documentation on that for my records, I would appreciate the appointment of that vehicle to Mr. Johnson, because as a board member, that conversation was never had with me. I don't know if maybe that was administrative and because it's probably standard, but very much like Public Works or the police department, if something is assigned to an individual, the usage of that property or whatever the case is, like you might be assigned a laptop. Do you get to take that laptop home?
So I think this is
Further.
different though, because they're not just saying that the vehicle was taken from Mr. Johnson. They're saying the vehicle was taken from the agency that was in the possession of Mr. Johnson. It's not just that it was taken from Mr. Johnson. This is an agency's vehicle that has been taken. He was actually the one that was driving it at the time, but the agency's vehicle is not in his possession. If you can show me where that, not me, but if you can show where that vehicle is in the possession of the person that the CRA entrusted with that vehicle, then yeah, but that vehicle has been commandeered from this agency, not the person. Let's talk about what has been done to this agency.
And that's why I said, let's specify in the policies what that looks like. Because if we're allowing you to take that vehicle home, that's an argument. If we're not specifying or expressly stating that vehicle can go here, there, everywhere. Can it go outside the town limits? Can it go outside the county limits?
Yeah.
Let's just clean it up so that,
Employee vehicle.
correct, let's just clean it up. Can you give Attorney Jackson any insight to, and let me reference the proper section in the bylaws, indemnification, I believe it's towards the bottom, for the purpose of liability of the TOCRA, its officers, its members, or its employees. Can you expound upon that article?
You know, it's interesting because I went through the indemnification section today only because of the concern that I have with the actions of the town. And how the agency may be responsible for having to cover the expenses of Mr. Johnson if he decides to sue the town. That it will be the agency's responsibility to reimburse or to indemnify him for having to pay those expenses. So from the standpoint of indemnification of TOCRA or officers or members, what it basically says is that if that person, whether it's a officer, a board member, or an employee, that they're indemnified or they have to be reimbursed if they have to expend monies for defending themselves in a lawsuit, or if they are, like say for instance, Mr. Johnson goes out and hits somebody with a truck. And let's say that he's not responsible, then he would have to, the agency would have to indemnify him or repay him back for whatever it is that he has lost from being injured or someone injuring him or him injuring somebody. Now, if he is doing that outside the course and scope of his employment, so let's say he goes out and he hits somebody with the truck, and he's not on town business. Probably a good reason for policy, if something like what you were just saying. So let's say, so yeah. So what it basically says is that if he does something while he's outside of the course scope of his employment, then the town doesn't have to indemnify him if he has to expend monies for legal counsel and things of that nature. So that's the indemnification, paying back for
Reimbursement.
yeah, for something.
Perfect. But as it relates to any sort of liability for the agency
Or
for
the
your
individual while
reputation.
working in the capacity of whatever for the.
Okay, thank you. Like I said earlier, we do have items on the agenda that speak to this.
And
So
Sheriff,
okay
I can
with
say
you.
something else
Yeah,
before we
please.
go into this actual meeting, because we ain't even really got into the meat of it. Let me make this clear, right now with Attorney Sheriff. Like I stated earlier, and I listed all the boards that he is over besides the CRA. He has no saying with this board. You understand me? Unless Attorney Jackson is not present. And then he still got to get the approval from this board to be able to concede or move forward with making any decision for us legally. Okay? So, and then on top of that, if he was given the authority to go and get an AG opinion, why didn't he reach out to the CRA attorney? Were you guys ever in conversation? And see, that's even more problematic. See, these are the things that allow upon us to really get a nasty litigation thrown against us. And I'm trying to protect the integrity of this board. That's why I said what I said. We're putting the motion on the floor, but we'll deal with that later. We're doing the right thing. I know a lot of time we sit up here and make tough decisions, but Attorney Shepard has no dealing with the CRA, period. Let's make that understood. It's a great separation. The CRA is a whole other entity within the town, even though we got interlocal agreements with policies and procedures, but we still got liabilities that we got to worry about. For one, right? Whoever went down and took that vehicle is dead because it doesn't belong to the town. I don't care if the mayor tell you to go and do whatever. You don't go and do it. You got to think logically. You know what I'm saying? Mayor, I can't do that. Hey, listen, I understand you're the mayor, but I can't do that because it's unlawful. But it was done. And that's not right. So that's telling me if we got a town vehicle, right? An employee got a town vehicle and you mad at them and terminate them for wrongfully terminate them, and you go to their house and take their vehicle, that's theft. Go there, call the cops and say, hey, somebody took my vehicle, and they found out that the town did it and he worked for the CRA, charges can be put on you. I'm telling you. And that's what we're facing right now. We're facing litigation that can get really nasty. And I don't want to do that because I've gone through that before with the same employee that did nothing wrong. And he was wrongly fired then. And he got paid. That's a lot of money. And I don't want the same thing to occur. That's why I'm telling you, Chair, I'm pleading with you right now because for the sake of the integrity of this board, to protect the integrity of this board. And then, like I said, even if we do reinstate them, and if you decide you want to put a motion on the floor to terminate them, that'll be up to this board to do it. And if we do so, Mr. Johnson, thank you and have a great day. You understand me? But I think we need to do the right thing by reinstating them and do it the right way if you want to get rid of them. If that's how you feel. Because we got an entire new board up here. And we got two other people that's got to sit up here that we haven't appointed yet. That I was moving forward to appoint, but for whatever reason I couldn't get a quorum because people said they weren't available. And that's even more problematic, if you ask me personally, because I think people that have just got elected should be making this stuff available. I think they should make themselves available. That's just my opinion now. And if especially if we're conducting town business, especially if we're trying to move the town forward, especially if we're trying to turn a new leaf. This doesn't identify with turning a new leaf when we're sitting here doing the same old, same old. You know what I'm saying? We always say what we want to do, and then we get in these spots and do the same old thing. The same old, right? So I can't sit here and predict if you're available or not. But I know I've tried having 3 meetings this week. Three. And the clerk told me there was no quorum. That's problematic. How are we gonna sit here and say we want to serve the people and be a servant of the community, but in the same breath, don't do it? That's a problem, guys. You know what I'm saying? And those are the things that we gotta, get away from. But neither here nor there, we will speak on this throughout the course of the meeting with the item that you did that you do have on here. And I yield my time.
If I can respond, and then I would like to move forward as long as there are no other comments.
Yes, ma'am.
To your comment about the attorneys. Attorney Jackson, I think we all recognize that you are the general counsel of the TOCR. I think we all at some point or another have leaned on your legal counsel and your guidance to move forward with this agency. I think because of the controversial nature of this situation, it is more than appropriate to consider the legal opinion or the legal interpretation of someone other than yourself. And I think that's due diligence.
Not without the board.
No, this is individual.
Because it's costing. How much did it cost them?
How
much did it cost them?
That's not what I mean. This is individual as board members. When you get your packet and you open your packet and you read your packet, if there's something in there about engineering, you get to call whatever engineer you decide to call, even if CPH is the firm of choice. You get to reference any professional that you deem fit as due diligence, not necessarily to dictate any action, but as a form of research.
But we did pay him for doing this.
Hey, you might have. That's what retainer is for. That's what retainer is for. However, to restrict a board member or a council member from seeking outside expertise is not right. I don't get to tell you who gets to tell you anything.
So
Very much. Let me finish. I don't get to tell you who you get to. I don't get to tell you who you get to talk to when you are not on this diocese.
Can't do that, sir.
I don't get to tell you who you get to talk to. When you leave out of here, you can make whatever phone call. Yes, I can. As an individual, I can make whatever phone calls, do whatever research.
But you can't do
That's my choice to make a decision about items that I need clarification on. Very much like Director Chair Gardner or Mayor Gardner reached out to a resource. I have that right too. It might not have been to somebody who we had to. I might have friends at Florida A&M Law School that have expertise in this field. And if I decide to call them to get information, I get to get that information and bring that information back for consideration to Attorney Jackson. I don't get to prohibit you from doing so. So to say that he has no place is false. I respect the fact that you are the attorney for this firm, for this agency. However, if I decide that I want to reach out to another professional, I have every right to do so. So do you. Furthermore, to your comment, you have to prove that. To your comment.
Hold on.
Yes.
So I think what I'm understanding is, board member Chris, you absolutely have the right to ask for outside legal advice. However, if they are charging this agency
Correct.
to provide you with.
That's why I respect your comment about that.
If you can't, then that is something
That's my
that
fault.
has to come through this board.
I'm not opposed to that.
So,
Me personally, I might not have called Shepherd
But I'm saying-
specifically
Whoever you call.
because we have him on retainer. However, like I said, if I want to do my due diligence, then I have the right to do that.
Yeah, sure.
And if I want to bring that to this board for consideration,
Absolutely.
I have the right to do that.
Absolutely,
But I do
100%.
respect your position
Absolutely, 100%. But it's gotta come through this board.
that information needs to come
It's
to
gotta
this
come through
board.
this board, but it didn't come through the board. That's what my
It was
gripe
sent
is.
to me
But it wasn't.
as a board
But
member.
listen, okay, even if that was the case, it didn't come to this board to make that decision on whether we're gonna pay him or not, whether on the town side or the board side, because we both legislators on the town side and we're board members on this side, okay? So it didn't come through us necessarily to be able to, whatever invoices he sent this town, right? And then it shouldn't even go through the town necessarily, it should go to the CRA, because that's who it's coming, that's who it's coming for. AG agreed, the opinion is for the CRA, not the town. We are legislators on the other side. It's a great separation. Like I said, I can't even discuss town business in this board meeting. I can't. Due to Florida statute and the ethics. But I can talk about board situations all day. That's why I tell you it's a great separation with Attorney Shepherd having any opinion on what we do on this board right here. Any opinion. If I have any legal council decisions that I want to move forward with, guess what I'm calling? Attorney Jackson, because that's our counsel. He's our counsel. And then guess what I'm gonna do next if I don't like his decision? I'm gonna ask this board, hey, listen, can I go on the outside and ask another legal attorney what their opinion is? That's how you properly do it. You don't do what was done because it's unethical, for one. You're not protecting the integrity of the town or the CRA because we're all connected at the end of the day, right? But it's a great separation. It's a great separation.
I very much agree that there is.
And if we're gonna sit here, and you're perfectly right, you can go and get 100 opinions. That's your right, Kara. I'm not taking that away from you. But my gripe is we're paying someone to do the same thing that our attorney can do. Right? And he said he was gonna give us the AG opinion. We ain't got it yet, but we got it in a matter of 24 hours from our own attorney.
I don't know what emails y'all getting. I'm getting all emails from Shepherd and from Jackson.
But he have to give us the AG opinion though.
Okay.
But now he did because listen, when you hold people foot to the fire, they move. You understand me? And that's what we did. We held them accountable. I want people to hold me accountable. If I'm doing something unethical or unlawful, hold me accountable. Period. I don't care what the situation is, but I'm gonna always turn my legal advice to our counsel. Anytime I'm having my report, I feel like the question I ask all the time, do we have any lawsuits pending against us? That's my number one thing because I don't want the taxpayers to suffer from our mistakes up here, making uneducated decisions. You know what I'm saying? All because we're in our feelings. And we can't do that because it's gonna cause us more damage than anything. It's gonna be detrimental, not only for this board, but for this community. And we don't need that. You know what I'm saying? I just feel like we need to do the right thing by reinstating Mr. Johnson, regardless of how, and I respect the fact that some board members or one board member want to table this item, but I don't feel like we need to because if you know the comprehensive policies and procedures already, ain't nothing to read. We already know how it goes. We've been sitting up here long enough to know, and if you haven't been sitting up here, you don't start up here before, and you know how it goes. So don't sit here and give me this about you need to read the comprehensive plan when you already know it. Why you can stall?
When I was up, I understand what I'm gonna speak to. When we was up here, when I was up here.
I'm speaking. I did not interrupt you when you were talking. I did not interrupt you when you were speaking.
From 1999.
I did not interrupt you when you were speaking.
I did this time, now next time.
I did not interrupt you when you were speaking.
Well, go ahead on, say what you gotta say, cause you're wrong.
I did not interrupt you when you were speaking.
Please continue to recommend.
And see, that's the thing about it. People hate to hear the truth.
Yeah,
The truth hurts.
you do
The
know.
truth hurts. And when you speak about the truth, you throw a rock, you hit the dog, and if you bark, there you have it. Right? And see, that's the thing about me. I'm gonna always be truthful about everything that I speak about up here. Whether you agree with it or not, I'm gonna tell the truth. And what I just spoke about with our own attorney and Attorney Shepherd, he shouldn't even come, his mouth shouldn't even utter out my mouth right now. Because he's not the CRA attorney. He's not. He's over all the different agencies I just said. Besides the CRA. And it's a fine line between that. It's a fine line between that. And according to the bylaws, listen, according to the bylaws, the Florida town I can't even speak right now, the town bylaws and the Florida statute, you have charter and the Florida statute, it's an indication that everything that Mr. Jackson said is true. We don't want to face the fact that it's true, right? And like I said before, whether you have a problem or you feel like Mr. Johnson ain't doing his job, but I feel like he's doing a great job. But if you feel like he's not doing his job, we reinstate him, right? We come back, and if you don't want him, put a motion on the floor to get rid of him. If you got the votes, we're fine. Period. Because guess what? I respect every board member up here. But if you're gonna do the wrong thing, I'm not respecting that. Okay? I'm not respecting that. Especially when it's coming from the town side, chair. And if anything coming from the town side associated with the CRA, it's a zero. It's a zero.
I know how you feel.
You know what I'm
I
saying?
know how you feel.
So, I think we just need to really govern ourselves accordingly. We gotta govern ourselves accordingly.
Can I use?
And I yield to you,
You
Chair.
wanna make another comment?
No, I
Okay,
do
because I
not.
have one more comment and we're moving on. The availability of this board should not be abused. These meetings are regularly scheduled yearly for the third Thursday at 6:30 p.m. every year. If there is an emergency, which there seems to have been, even though it was not defined in the email that we received, then I'm amenable to meeting and convening and talking. That's what we're here for. It's the only time we get to talk is up here on this diocese. I'm amenable to that. What I won't be is dragged around because someone feels something. We had a meeting scheduled for today anyways. I'm not saying that it should have waited. I'm just saying my schedule was already built. I personally didn't have the availability. And where I could make an accommodation, I did, which is why I appeared on Monday on Zoom. And I spoke with the clerk to see if the time was adjustable in any capacity. I'm not available on Friday. And I'm sorry for that. I'm sorry for my unavailability. But what I won't be, because I am now elected, is available for not for no reason, but just because. Town business gets handled every day. We don't meet every day. So I think we ought to be considerate of one another's time. Like you said, we have jobs, we have families. There are emergencies that will arise. We have policies and procedures that are in place. So I don't want us to think that if Ruth has a problem tomorrow, stop what you're doing and come running to this diocese. I want us to be as respectful as possible because we're working together. Regardless of difference of opinions, we're working together. So I just wanted to address that because I know that that's something that you feel strongly about and that you have addressed before. I want you to know from me, I can't speak for none of the other directors up here, but from me, if I'm available, y'all know I've never run from a conversation because that's what these are. These are conversations, heated in whatever capacity, but these are conversations. I'm not bucking that. However, I was not available on Monday. I am not available on Friday. If the clerk does poll us again, which I think that we should, because we talked Tuesday about postponing the appointments to the board because we wanted to save Tuesday for the celebrations and all that, but we do understand how pertinent these two seats are that are open, and we do have extremely important. I totally agree. So I definitely think that we can get with Ms. King to go ahead and get some meetings scheduled so that we can finish out.
Already pretty much.
I got the email.
Yeah.
So that we can put out another opportunity to speak. With that being said, we are ready for citizen participation. It's on the agenda. Because it came after the presentation.
Yeah, it's on,
Whoever created the agenda.
yeah, it's on here. But
I was just
doing
ignoring it. We are ready for citizen participation. Ms. Bellinger, do we have any participants?
Yes, we have this Joyce Arden, she's not here, but she sent in her formulas.
You may read it into the record.
I'm surprised when I attended the evisceration of Cliff Shepherd disguised as real me. Attorney Jackson decided to hold a trial with himself as judge and all witnesses as he repeatedly impunged the reputation of our town attorney and blamed him for everything while staking his own reputation on the purity of Mike Johnson. I believe Mr. Johnson's swindling, hoodwinking, chaos causing, intentionally vague, pushing the margins, slick talk, and behavior is not Cliff Shepherd's fault or responsibility. Cliff is not causing the confusion. Mr. Johnson's lifetime of behavior creates drama and confusion. Mr. Jackson appears to be jockeying for position in a matrix where it seems only he, Mr. Johnson, and 2 council members exist. Mr. Jackson basically called me a liar regarding me saying this mess with Johnson is going on forever, then and now. He has no evidence, and here are a few things most of us already know. Aside from cheating me of approximately $1,000 in 2021 while using the name of Eatonville to do it, is shaking down David for $70,000 regarding Club Heat for what I believe he characterizes as a special consulting services, maybe the ones he used to bribe the Chamber of Commerce out of $30,000. I believe he always has a scheme to profit for himself at someone else's expense, mostly the citizens of Eatonville. Someone not submit to a shakedown and also him suing us and getting what I think was another 70 grand due to our council's collective confidence. I will quote an excerpt from Welcome to Eatonville in the Orlando Weekly, published November 7, 2002, in an expose by William Dean. Quote, according to the FDLE reports, in 1994, Grant instructed his personal secretary, Tammy Stafford, to falsify a document as part of a smear campaign aimed at a political rival named Marilyn Curtis. Stafford told the FDLE she wouldn't switch the name, so Grant convinced his friend Johnson, a businessman who later won a seat on the council, to do it. By the time she saw the facts, it was part of an anonymously distributed political smear campaign dubbed Dirty Deal Part 1, Part 2. End quotation. This is not about Grant. This is about Johnson's forever behavior and his decision not to be better. This is not personal. I wish he would stop giving me things I feel I must speak about. So much more I have, but time is levied against the citizens. I will close with something Valerie Flower said. We never learn to disagree politically and not take it personally. Everything with y'all seems personal. Nobody is handling town business. This feels like business. Next we have Angie Garner.
Good evening, everyone. Angie Gardner, 535. I was here to give my time, but I really need my time. I don't blame anyone for any of my actions. Attorney Shepherd was only involved because we asked questions. When the suspension happened, it happened as the chair. You keep hearing mayor. I did not act as mayor until I had to. I acted as chair. Your bylaws do state, and it's underlined, that the chair can suspend the director. It says termination is by the board. So I suspended Mr. Johnson, not because of an evaluation. It was because of insubordination. And I don't want to go in that deep, but I need to tell you, because if the chair can suspend and the board terminates, this was all over an evaluation. I was leaving office, had not done an evaluation, and I knew the board should be a part of that. And there were some things that had happened that really concerned me. So I said, we need to talk about it. So I called 2 special meetings. You weren't available.
Ooh.
Director.
Nobody called me for a special meeting.
But I called 2 special meetings.
Nobody
There was
called
no
me for a
quorum.
special meeting.
Twice, no quorum. So the suspension was for 5 days until this board met today to determine any further disciplinary actions. I did everything in my power. During that suspension time, and it's also in your documents, there should be no work by the suspended person. There should be no town business at all. That same night, and we sent the police officers to deliver it because people can pop off. What what employee was gonna deliver it.
That's true.
But we sent the police officers because that was safety. But when we sent the police officers, that was a Friday, I believe. It was a Friday. By Friday night, Mr. Johnson was using town equipment to set up a special meeting. Now, he was suspended for insubordination, I told you. So he didn't get the 2 special meetings. I tried to do it as chair. So suspended, but during suspension, you kept breaking the rules of the suspension. But even when I didn't get a special meeting, I asked for a face-to-face. Hey, Ms. Johnson, I gave 3 dates. The first date, I'm unavailable. And I'm going to forward it to Attorney Jackson. That's when the attorneys got involved. When I received the email from Attorney Jackson or whoever it was sent to, I sent that to Attorney Shepherd. That's when the attorneys got involved. We didn't do it. It's not Attorney Shepherd's fault. He also answered what was asked. So then that was the first time. That's the time, that's my time. Yes.
I yield my time.
She yields her time.
I yield my time.
Thank you. So 2 minutes, right?
No, I thought.
Okay, so then I tried 2 more times. That was on the 12th. I said 4 o'clock. Or you could do the 13th, 9 a.m. Gave you a afternoon and a morning. A Thursday, I'm in class. I'm going to be on sick leave Friday, Monday, Tuesday. Who's going to be on sick leave for medical reasons? I don't know if y'all got a medical excuse. I don't know. That's insubordination. When the chair asks you to come for an evaluation. So that is when the evaluation occurred, suspended for 5 days until this board met, pending further disciplinary action. During that time, violated all terms of the suspension. So who has to step in?
The mayor.
I wasn't rogue. I was doing it by book. And as mayor, you have to shut it down. I'm not gonna put that on Attorney Shepherd. That was me as mayor. So if you're gonna sue the chair and the mayor. But I did it by the book. And when something doesn't go right, ultimately it falls on the mayor. It doesn't matter if the TOGRA exists because of the town through an interlocal agreement, delegation of authority. I wasn't trying to overstep. I was trying to do my job. And no one has the ability to just do what they want to do. I know I'm saying that. I said that, y'all. Do what they want to do without some sort of consequence. And that's. Oh, by the way, and please, if you're gonna vote on that consent agenda, please pull items 5 and 6 so you can at least discuss it individually.
Not sure.
Yeah.
This is the very thing that Florida statute speaks to. When Ms. Gardner stood up there and said she did what she did because she did it as the mayor, that is what the law states should not be done. So, and also when she sent out the letter, she didn't do it as the chair. This is on town of Eatonville stationary. So when she said that she called as the chair, she says in here, employees of the town of Eatonville are required to conduct themselves in a manner that supports the efficient operation town government. He is not a town employee. He is a town of Eatonville Community Redevelopment Agency employee. So that goes to show why Florida statutes and why there are Office of Inspector General investigations and audits because of those very statements.
Is that the termination or the suspension?
This is the letter with the evaluation. So
Which
from the
is the-
beginning, from the very
Okay.
beginning, this is on town of Eatonville stationary. The evaluation,
Even if it's signed chairwoman.
this time chair/mayor. But
I
this
see
talks
chairwoman.
about, right, this talks about, no, the letter is,
Dated, is that the suspension?
this is the evaluation. This is from the
What date do you
beginning.
have on that?
This is from March 16th. This is from the very beginning.
Okay.
So.
I have March 13th with chairwoman.
Well, she should have had it, but I think
Attached
it's
to-
13th. It should have been dated the 13th because that's when it was actually done. So I don't know why this date is wrong when she's talking about, so that's a whole nother issue, but that aside, this talks about town of Eatonville's policy. He is not a town of Eatonville employee. That is the problem. That's why you're here right now. That is the very very thing that the Florida statutes has tried and is protecting against, that's not being recognized. And even now, it's not being recognized, which is unfortunate.
So the letterhead is what's bothering me.
No, the statement. The statement, that was an incorrect statement, that as the mayor, I have to step in to CRA business.
That's on record.
And I'm only referencing the suspension. Because when she first spoke, she spoke about her authority to suspend as the chair, and that the termination came later as mayor. I don't have a termination letter. I do have the letter that was attached to the evaluation that is on Town of Eatonville letterhead, but it's signed chairwoman and speaks as the chair of the Town of Eatonville and as the mayor. She did put that in there, but it does state as chair. It is signed chairwoman. Very much how, that's what I have here in front of me. A copy of that evaluation receipt
Mayor,
on the evaluation.
right here.
Okay, are we referencing the letter that is on town letterhead?
On your-
Yes.
On town letterhead,
Yeah,
and we can talk with HR or Ms. King or the CAO.
well, no, you talk to the board.
But what I'm saying is, we're referencing comments that she made just now, and that's what you're referencing. You're referencing her authority as chairwoman.
No, ma'am, I'm referencing the whole situation.
I understand that, but your comment was in response to what she said. Was
Based
it
on what I
not?
said, she said that she did everything as the chair.
She said she did the suspension as the chair.
No, you said-
Yes. Do we want to bring her back up? She said the suspension was as chair and that the termination was as mayor.
Well, I'm saying that she said that she was evaluating him.
At the chair, it seems that she can.
Right.
Please,
As the mayor,
please
but-
clarify.
But,
If-
but,
okay.
hold on.
Yeah, if you wait.
But what I was saying is that whether she was doing it as chair or as mayor, it is on town letterhead.
I understand that.
It's on town letterhead, and it's signed chair and mayor, and it talks about town
And
procedure.
you have March 16th on that?
March 16th
I
on,
received another letter on March 16th that speaks to the termination. But the suspension that I'm referencing,
Okay.
I have for the 13th. And then I know that I
Yeah,
do. I got that from HR.
so I have the evaluation from the 13th. The evaluation is on town of Eatonville, on the town of Eatonville evaluation. The evaluation form is signed mayor/chair/mayor.
And it should just say
Chair.
chair, not mayor.
Right.
You
And when,
still can't do it as the chair.
right, because she didn't have the authority of the board to do any of those things.
Okay, and then that leads me to my second question, because my second question is, does the policy and procedures give any authority to the chair to do said responsibilities?
There is a progressive action policy in the policies and procedure manuals for the town of Eatonville's Community Redevelopment Agency's comprehensive policy and procedure manual. The progressive actions were not followed.
But is
Or not.
there authority in that policy and procedure manual that gives her any authority at all, whether progressive or not, to give an evaluation or a suspension?
So listen, ultimately, there's permission to fire, but you have to do it the right way.
Understood.
So is there permission for her to suspend if she does it the right way? Yes. I'm not saying, no one has ever said that the chair, when it is done appropriately, can evaluate the TOCRA employee, and the chair, when done appropriately, can suspend the TOCRA employee. No one is saying that. What is being said and what's being admitted, and that's in a public meeting, is that acting as the chair, using town of Eatonville's forms, signing as the mayor and the chair, and ultimately making the decision without this board to terminate a person as the mayor. When I did this, I had to step in as the mayor.
Can't do it.
That is exactly what Florida statutes warns against. And that's
I understand. I just wanted to clarify because I heard it said, and I very much like Director Thomas, I've been on this board 3.5 years and I've never received a copy of those policies or procedures. I have never seen them prior to this incident. So I didn't even have anything to reference other than the bylaws and the understandings of this board. But if you're telling me that these policies and procedure give permission as chairwoman, progressive or not, for the chair to do an evaluation, a suspension, a termination, or prohibits otherwise, then I will side with you. And if it does not, then I'm remaining where I stand. that she
So-
did in fact have the authority to do an evaluation. I did see the request for the special meetings. I know we weren't.
So that,
Available.
the policy and procedure manual says, this is what the policy and procedure manual says.
Can you reference the section so I can follow with you?
4.13, it's like, page 90. Not 83, page 83 of the policy and procedure manual, should have evaluation, 4.13, one something, you'll see it.
Can you go
Because
one more
that's
time
it.
for me?
83.
I
83?
want to say 83, maybe 84, something like that, but it's down there somewhere. And if I find it, just let me know if there's someone who see it. But what it says is that the board is charged with evaluating the TOPA executive director. That's who.
He said,
Hold on one second.
83 is 4.7, I think.
Oh yeah, 4.13 is on page.
79?
That's that. 79. Not 79. Yeah, so 4.13.33, I know it's 4.13.
4.13, okay, I'm sorry.
Listen, the board shall, when we talked about the word shall, the board shall evaluate the executive director, point blank and period. Now, it says, per the requirements of his contract. However, in the absence of a contract, then this board must establish what those evaluation criteria are. The board chair does not have that authority to evaluate. That is not the board chair's role pursuant to the TOPA comprehensive policies and procedure manuals. Now, you asked the question of no one seen these policies and procedure manuals before this situation came up. No one had a reason to.
We should have had it just because we're board members.
I'm not saying that if you requested them, you shouldn't have seen them, but up until this time, I had no reason to look at the policies and procedure manuals to determine if someone has been properly evaluated and properly suspended and properly terminated. It was after that happened that I said, well, let me see what the policies and procedures say. I never had any reason to look at this, but this clearly states that the board shall evaluate. Now, Attorney Shepherd, and let's talk about this because it's early.
Before you go there, if it says the board shall evaluate, then that means that he should have gotten evaluation from each one of us.
No, the board,
Us.
not board membership.
Him sitting there and us evaluating him.
When you talk about, you're talking in bump, you're talking the board. You're talking this board. Now, I wanna address one thing, and the reason why this concerns me, and Board Member Mack, this is really to address something that you said earlier. Why you look to the CRA attorney for advice and things of that nature. And I don't fault anybody for going and asking anybody questions. That's your absolute right. I've never said that. But on more than one occasion, the town attorney has given this board advice, and it was wrong. The town attorney in the past had given this board advice based on the TOPA, on the CRA plan for 2015. Not knowing that the 2015 plan had not even been ratified and adopted by this board. And he was given advice based off of a plan that was not even in existence. Now listen, if he just would have called me, I would have said, Attorney Shepherd, number one, let me answer that question for the board member, but we don't even use the 2015 policies because they haven't been adopted. And I know that because I was around in 2015 when Tom Kohler put it together. Even tonight, I mean, it's as much as I have to go through every statute, every opinion, every policy, every email, everything to justify what I say. Attorney Shepherd can give you all a OAG opinion that does not even fit the circumstances, and I'm still having to battle what he's saying. When the OAG opinions that I provided are directly on point, but he gives a OAG opinion that deals with dual office holding, and one that deals with someone who's trying to quit a CRA board, who's still a part of the council, but he can't quit the CRA board. But I'm still having to justify my opinions. At every turn that I take, when I give this board sage advice, and if I've ever given this board any advice that they could not take to the bank, somebody please let me know. And so that's why for me, when Attorney Shepherd asked me, well, Attorney Jackson, why is it that you don't like when I give opinions? Because they're wrong. Because you're creating conflict on this board. When you're telling them things that I'm telling them, that is not the way things go, and you go and you find some language where you just look up the title and say, oh yeah, here's something on point because Attorney Jackson is wrong, and Attorney Jackson isn't wrong, that is offensive to me. And when Miss Irby says, when she says what she said, I have on record, because I had to go and listen to this with my wife again, where Miss Irby in a meeting said that Tom Kohler speaks truth to life. And I don't care if you think that he's in the Klan, you need this man. Those are her words, not mine. But I'm being challenged when I come to this board and give reasons why Mr. Johnson was wrongfully terminated by the mayor, as she admitted. Where am I wrong? What have I missed? When Florida statute says that these things are separate, how am I wrong? How am I being challenged? When all I'm doing is recitating Florida law. So yeah, I don't come on the town side and give opinions as much as I've been asked sometimes, because that's Attorney Shepard's purview. That's his stomping ground. I don't come over there. But when he comes over on my side and he's giving my board wrong opinions, of this board, not my board, this is y'all's board, and he's giving this board the wrong information and causing this type of conflict, I have to step in and I have to wonder, well, why is it that when I say something, I'm being challenged at every step, even though I'm right? That's troubling.
Can we yield to,
Yes.
so she can sit down?
Before she speak, can I ask her one question?
You wanna ask her a question?
Yeah, I want to ask you a
Absolutely.
question, former Mayor Gardner. Could you please tell me, as a former chair, as CRA director, board member, why would you go to the council for the town to get an AG opinion versus going to the actual CRA?
Because if you read the signature bylaws, it is even underlined that, first of all, the chair can suspend, but if you keep reading your documents, it states that the executive director is an employee of the town. It states it, black and white.
No, I ain't asked that question. I
You
asked,
just asked me,
I asked
so
why
why
you
was
didn't
the
go
town
to,
employee at the town side?
no, why, I'm asking a question. Yes or no? Why didn't you go to the CRA attorney versus the town attorney?
Oh, okay.
That's what I'm asking. Why did you go to the town? Listen, as a chair,
Let me
it's like you, if you go to the town attorney versus seeking opinion from your own CRA attorney, who we pay very well, go sign the checks.
Ask the question. No, I am.
Why would you do that?
Because you've been ignoring my calls.
Oh, okay, well, I wasn't aware of that.
I received when we were out of town, when my concerns first started. I
You
called,
to that.
wait, let me, when my concerns first started, I said, man, let me go ahead and get the evaluation done. First of all, if the board is gonna do an evaluation, what you gonna use? You don't have administrative hands. That will come through the chair, and that's the administrative side. Because he was hired under the town. He signed the town documents. They're signed, he acknowledged, and for yet will.
And you gotta be
So,
sure with us, though.
let me, well, I gotta have a meeting with you, but if you don't come to a special meeting, there's no meeting. But in the meantime, if you received any calls during that time, which some of you did receive a call, not to come to the meeting, so there was no quorum.
Who said that?
But that, let me just say what I
I'm
know.
assuming now.
That was maybe not all of you. All you need is, you need a quorum of
You can't
four.
assume.
But let me finish. So Attorney Jackson was out of town. And when he touched base, he did call me. While he was out of town, I sent the information that concerned me to him. When he touched down, he did call. I explained the issue. I may have spoken one more time, and then after that, it ghosted. Not only did Attorney Jackson not return in my calls, the staff didn't respond. I said, please call me. And I sent an individual text to each staff member. They didn't even call me. Which is why when they came back to the building, they were locked out. There may have been complaints as to why the building was locked. They started ghosting me. So, and I wanted to explain why it says chair and mayor. Because when I tried to do an evaluation, when I tried to call that evaluation, I was told that's not my job. So how does it get to the board? Where are you gonna start from? You start from, let me finish. You start from a document that already exists, which is our evaluation document, because he was hired as a town employee. He's on a pension.
But he's.
So, get the definition of an employee. Get the definition of an employee, and you are being misled tonight. No, you are being misled by Attorney Jackson. You can't, you let legal fight legal. No, I'm speaking now. You let legal fight legal. Because it sounds really good to people that don't know what's going on. But you need to let legal fight legal. And if it needs to end up in court, let it end up in court.
No, that's gonna cost the taxpayers money. No.
We are going to move forward with the remainder of public participation. We are going to move forward.
It was chair and mayor on there because of the conflict. So I kept both terms. That's it.
Attorney Jackson.
Thank you, Chair, and I have to address it. Mr. Johnson is paid through the CRA trust fund, not the town.
Is there a reimbursement or is it direct?
It's reimbursed.
Okay.
He is paid through the CRA
You
trust
have
fund.
a local agreement?
Yeah, interlocal agreement. Also, he pays for his own benefits, so she says that he's paying for his own benefits. See, that is not being paid for by the town, but now, we're talking about, since Ms. Gardner brought, that is Mr. Johnson's personal information that she's bringing up, and that's fine. Now, I want to talk about when Ms. Gardner called me while I was in London on my birthday. That's where I was when she called me. She called me to ask me about a flyer with Councilman or Board Member Washington's face on it. That's why she called. I told her I would take a look at it. I didn't see anything there, and I told her I would talk to him, and that was it. There was no reason to talk to her. When she reached out to me on the 23rd, I spoke to her on the phone. She wanted me to say that Mr. Johnson was an employee of the town, and I said, let me take a look at the information. Like I tell every one of y'all, let me take a look at it. I told her, and I know I didn't call her back because I sent her a written document saying that he was not an employee of the town. That's how I responded. Not a call, but I responded to her in a text. She sent me a text back and said that Attorney Shepherd disagreed with me, and that was the end of it. There was no need for us to correspond after that because she had made her decision that Attorney Shepherd was right and I was wrong. So I did not ghost her. That's not a correct statement. I've never ghosted her. If I don't respond to a call, I do send emails, and that's what I did with Ms. Gardner.
Thank you for the clarity.
Thank you.
I respect for the rest of the public participants, we are moving forward. Like Ms. Bellinger, who is next?
Next we have Brian. And then we have Selena who is field. So you'll have to qualify.
Thank you.
Good evening, Chair, members of the board, members of the community. The CRA's mission statement calls for aggressively pursuing redevelopment and serving as a catalyst for public and private investment. That's not my standard, that's yours. Tonight, I want to ask how we're measuring up to it. Eatonville sits between Winter Park and Maitland, two of the most affluent communities here in Central Florida. Property values have risen over the last 29 years this board has been in effect, not because of the CRA's involvement in beautifying or revitalizing the community to increase property values, but simply because of geography. The CRA has had nearly 30 years and millions of tax dollars to increment and accelerate the trajectory and improvement lives for the residents. The question worth asking is what we actually have to show for it. If the CRA can just return unspent money to the town as a rebate anyway, there's no urgency to actually deploy it. The CRA becomes a bureaucratic layer that employs people, pays vendors, and returns surplus funds without transforming anything. This year alone, the CRA will return $1.5 million to the town, nearly 7 times what was budgeted as rebate. That's not surplus. That's redevelopment that never happened. I want to address something directly. At a previous meeting, when these concerns about 29 years of limited progress were raised, the response was that there have been projects in recent years. If you have only been a part of this CRA for the last year or two, I understand. You can only speak to that time. But if you've been on this board or employed by this CRA for any period of that 29 years, I expect you to address the full record, not just the most recent chapter. Additionally, it was brought to my attention that a routine public records request was pulled for project records, contracts, and expenditures back in February. And after nearly 4 weeks of silence, a response was given to the estimate of $5,000, 120 hours at the executive director's hourly rate. And for those who run the math like I had to, that's 15 full working days doing nothing else. To produce records that should be routinely organized and immediately accessible if this agency is operating as it should. Every dollar spent on questionable expenses and potentially inflated vendor contracts is a dollar that came from every resident tax bill, and is a dollar not going towards the redevelopment that justifies this CRA's existence. Looking at the financials before the board tonight, I have several questions. For payments exceeding $7,500, including payments to Roads and Bridio, Classic Home Developers, and Next Tier Builders, where is the board resolution authorizing each? Section 3.4.3 of your own bylaws, the executive director requires board approval for any purchase over $7,500. Roads and Bridio will receive over $40,000 in a short period. Can the board describe what specific projects or scope of work this represents and confirm it was competitively bid for? Classic Home Developers will receive $19,000 for infrastructure improvement. Can the board confirm that this contract was competitively bid and disclose the nature of the work performed? Next Year Builders received a $20,000 check that was voided, wrong amount, and reissued at $5,000. Can the board explain what changed and what contract governs the relationship? The trust account debit card also shows charges at restaurants like Chipotle and others, and multiple Amazon purchases. Can the board confirm these are legitimate documented CRA business expenses? This community deserves a CRA that operates transparently, spends public dollars through competitive and documented processes, and produces visible results after nearly 30 years. If the CRA is approaching the end of its authorized term, what it does with this remaining resources in its final years matters more than ever. I'm here because I believe that this board, with its new memberships, has an opportunity to set a different standard. 3 or 5. All right. Look forward to seeing that happen.
Do we have anyone else?
Now we have Dr. Candace Smith.
Her time. Her time. She was you. It was you.
Then we have to go back next. Peyton Gardner was next.
I got her turn.
Then we have,
You miss me?
no, you're next. Michelle.
Thank you. I got a lot to say in a little bit of time. Happy Tuesday, everyone. Happy Tuesday. Stage. See how we go back to that. What is this? Somebody buying my kid dinner tonight. I'm just saying. But I just want to say thank you for tonight. I know that you guys are having to hear a lot. But I have to say, I'm along with Ryan. I looked, I know you guys have the documents in front of you, but when I looked at these documents, Mr. Johnson has a subscription to TextStar. This company helps you to make sure your text messages don't have any plagiarism in it. That's $19.99 a month. That's considered a agreement. He also has Zoom for $15.99, ChatGPT, which is free. He also had, I want to find out about the travel reimbursement, because that should be based off the state statute. And it depends on if you're gone 24 hours or not. We have Garcia Media Group, that's $125 a month, and they've been paid 4 times already. But I could just go on, you guys got to check out the agenda online, it's all there. I want to say, I stand in termination. What I'm requesting this board is to look at the past receipts for 6 months. Because I am requesting a public records request. I want to see the receipts, I want to see the approval, I want to see the checks. Because Ryan's right. Classic Development, $19,000. That's Anthony Grant's company. Okay? The other thing I want to bring up, I think it's on page 10, miscellaneous, no, I'm gonna go to books and publication. The budget amount is $7,000. $16,834.40 have been spent. And this is just through February. $9,834.40 over. I don't know what kind of books you buy, but that's a lot of books. Miscellaneous expenses, $7,500. Budgeted, $8,878.19. So needless to say, we need to audit to find out what's actually being spent. And I do want to say this, Attorney Jackson. What you said that Monday night, I didn't agree with it. So I like to go home and look. I'm not an attorney, but what I will say, Florida Statutes Chapter 99 talks about candidates, restriction on individuals qualifying for public office. So you have to put in your resignation, right? And what it says is, the office is deemed vacant upon the effective date of resignation submitted by the officials in his or her letter of resignation. Upon means thereof and at that time. So when they put in that resignation, that was done. But you mentioned something else about Cliff and how he doesn't get involved. The last time Mr. Johnson was fired, Cliff was there with you. You both were in that room. And he did make matters there that said, you both say you needed an expert because he had a contract. That's December 2019. I think it's October, whenever he got fired and brought back. The other thing I want to talk about is this. When I said that he wanted to give he wanted to do merit pay for services that were performed prior. And you said that you agreed, you said that they needed to have a policy written. Well, when I went to look, Orange County Comptroller's Office in December 2019 said that that was a violation, what he did. And Mr. Johnson was the director then. But I have an AG opinion that says the payment of bonuses to existing employees for services they've already performed and have compensated for will violate section 215.425 Florida statutes, unless there's a pre-existing employment contract, making such a bonus part of their salary. But this is what your statement was that night when we discussed it. You basically told us this. You said, prior to the board making this decision, you had expressed that let me take that back. You said, advised that it is not legally required for the board to make a one-time payment decision in the absence of such policy. He explained that at present, awarding merit pay is at the board's discretion, but recommended that the board develop and adopt an official policy to govern future merit awards. Why would you have them do that if they receive a violation from Orange County Comptroller's Office, December 2019, and then he does it again? This is a history. Mr. Johnson employee is rightfully so terminated. We need to review all documents and any dealings that he has been doing because they are not authorized. So just to say what Mr. Clifford did, I got an AG opinion for you too. Here you go, pass that around. Thank you. I got an extra copy too.
Do we have any more, Ms. Bowen?
Yes, so our last participant is Angela.
Good evening, board chair, board members, residents, attorney staff. I'm not gonna reiterate the number of things that have been stated tonight. I would just challenge or invite you to consider looking at some of the common practices for CRAs that exist throughout the state of Florida regarding employment practices for employees, evaluations and terminations. Also would, I echo former Mayor Angie Grant's recommendation that you move.
All night.
Where you move your items 5 and 6 from consent agenda down to board decisions. There's always been a concern of walk-on items that are being presented to you that does not allow the citizens the opportunity to review such documents before they come before you. I think that we, especially with the CRA board, it seems to happen more frequently than the council meetings. That you publish one agenda with 1 or 2 items, and then when we step in as residents, there are 5, 6, 10 items. And you, as board members, do not have the ample authority, time to consider them and review them, which I think is disrespectful. So I would ask you tonight to table whatever these amendments are to your CRA bylaws, as well as nullifying, well, items 5 and 6, until you can actually review those documents in totality. Thank you.
That was it.
Attorney Jackson, can you confirm whether or not a motion is necessary to move those items? Just for my refreshment.
5 and 6.
Yeah.
So if you don't want to consent agenda, yes, sir.
I'd like to entertain a motion to move items 5 and 6 from the consent agenda down to board discussion.
Or do you want to table it? We can just table it instead of having a discussion or decision. We can just come back to
I
it.
know you wanted to talk about 6. Do you want to just, we can table it if that's the desire.
I'm just saying, like, I think what has already happened should be rewarded with you making that decision because you are the chair and reinstating him. You know what I'm saying? That way we don't even have to go through the theory of even tabling an item or coming back to it. If we could make sure that that happened, what this board already did. I know you guys wasn't here, you was in the Zoom meeting, but it's already been a decision made, right? And I think we need to be respectful of the decision that was made by this board, you know? And I know we sent up here with, one other board member besides ourselves, because we've been sitting up here besides one other board member, and we gotta put 2 more of these seats also. But it's already been rectified on what we need to do. That way we can protect the integrity of this board, this town, and the employee of the CRA, which is executive director of CRA, by bringing him back immediately. First, because it's already been established. And I know what board member Ware said, is it gonna get done? We've already been through the motion of doing it, right? So if we don't proceed and moving forward with making it happen, we're putting ourselves at jeopardy. You know what I'm saying? By being, having litigation and we don't want that. So to eliminate this, let's go ahead and as you as the chair, you're the chair. Okay? And I think we definitely need to move forward with reinstating Mr. Johnson. But it's already been established though. We just need to make it happen. You know what I'm saying? Ain't no need, like, remember what I said, there's no need of going back to it because we've already done it. It's already been done and established. So this, if that could happen, we can that and then we can table amending the program for the bylaw. It's just my opinion. But it's up to this board though to do that. Or we can put it back out there, then that we got a new board and make our decision that way too, board up or down, on whether we want to reinstate them, because we got a quorum. correct? But, you know, we're kind of struggling on the fence with that because it's already been established and done. But do we want to go back to doing it again? And that would have to be something that we can speak to the attorney about.
But in the process, if you're saying that you want to redo it all over again, that means that you're going to have to go back and basically scrap the decisions that was made at the meeting on Monday.
No, but I would rather go with the decision that's already been made
Right.
by this board, because, Chair, you are part of this board, you was a part of it, but you couldn't vote that night because you was on Zoom. But you are part of the process. You're on this board. You're every bit to do with this board, whether you voted or not. It's still our decision, you know what I'm saying? So I would hope, and then I'm in hopes that we could move forward with reinstating Mr. Johnson back to his duties, right? And in the near future, if anyone feels the need to come back to this board and say, you know what, I don't think Mr. Johnson is doing the job that we require him to do, then we can put another motion to file if that's the case. But I with the respect of you sitting in this chair, because I know this is a great responsibility. And I want to, you know, protect you, this board, and this town by doing the right thing and bringing him back. And then if we feel the need to go a different direction, and we can put stipulations on it also. We got authority to do that. You know what I'm saying? Put stipulations on him if we don't feel the need of him fulfilling the need of doing his duties that we feel the need of him doing. So that's something that we need to definitely strongly consider also. But Chair, if we could, you know, go with what we got already, that'd be great. That way we can avoid putting a motion on the floor. And I know I put one on the floor, but of course.
My recommendation would be to table items 2, 3, and 4 for another meeting. 2 through 5 for another meeting or potentially a workshop, because we know them bylaws are not a one-night thing. And we know how drawn out they can be. It would be my recommendation to table items 2 through 5 and move item 6 down to board discussion, potentially board decision, if we decide to move forward in that direction tonight. And I will also incorporate the attorney to say, with the statements being made that actions were done outside of the legal authority of individuals, it would essentially negate itself, if that is the understanding of this board. And if that is the case, then I would support entertaining a motion to determine whether or not we wanted to move forward tonight with this quorum, with these appointed board members about the director's employment. Is anybody on this board in opposition to that?
Is that a motion on the floor?
I'm asking before I move the motion, if anybody has an issue with moving 6 down to discussion and potentially decisions.
Okay, I got another question before we move forward, and that's what relate to the attorney, because that's what I relate all my legal life to questions. Do you think this would be something ideal for us to do for this particular moment?
So the issue that you all have right now is you have the decision that was made by the board to return Mr. Johnson to his employment, to return the vehicle, to return him with full internet access, email access, so he can perform his duties as a total executive director. That decision has not been honored. And if this, and it's completely up to this board, but understand that if this board, if it is not followed through, that those things are not done, and that places this board potentially at risk for litigation. Because now you have an individual, an employee, who will have an argument for wrongful termination, for harassment and intimidation. If this board is okay with that, then that's the way that you proceed, but that is the situation that this board is in right now. As for the bylaws, if you look at your bylaws are up for annual review, and it's not until April. Correct. So I was going to suggest that move to a discussion anyways, because you cannot actually act on your bylaws if you want to until April. So you still have some time for that, but the one dilemma that the board has right now, that there's a decision that has already been made, that has not been respected and acted upon, that needs to be taken care of, or potential legal consequences will come about.
And Chair, if I can, thank you, Mr. Jackson, Attorney Jackson. Being that it's been said, I think it would be a great idea and, something that we can probably move forward with if you could, possibly, concur with me with more of what we've already done, especially with you being in that meeting on Zoom and you kind of heard all the information that was already gathered and, gave to us by, Attorney Jackson to reinstate him, something that should have been done anyway. And I think what we can do also, right, is this board evaluate Mr. Johnson in April. And if he meet the qualification of, retaining his job, this board will make that decision. But if he doesn't, we'll also make that decision to get rid of him. So I think that would be more fair to him and his board if we can move forward with doing that. But first things first, let's concur what happened on Monday, on Tuesday, Monday, whatever day it was, to reinstate him, right? You heard all the information. Everything's already been established. You're the new chair.
But not sure, but I understand what you're saying.
You know what I'm saying? So, yeah, so I think that would be very ideal for us to do as a board, because I wanted to make sure that we are turning a new leaf and having a different perspective on how we do business up here also. I don't want to sit here and go back and forth about this. We're gonna, have our differences no matter what. We're gonna agree on some things no matter what, and we're gonna have our indifferences no matter what. But I want to make sure that we're making the best educated decision up here to save ourselves from litigation, for one, right? And most importantly, protecting our integrity, because I feel like this is a great board that we sit up here with, and I feel like we can get a lot of things accomplished. Due to what one of the residents said, Mr. Ryan Novak, we got to move things, man. We got to turn some dirt in this community. And Mr. Johnson is doing a heck of a job, but let us bring him back, and then we can evaluate him in April and make that final decision on if we want to keep him or not.
So then I'll circle back to what my question was. I'll entertain a motion to approve the consent agenda, or excuse me, to table the consent agenda, items 2 through 5 to the April meeting, and move item 6 down to board discussion with a potential decision. Do I have a motion?
Second.
Hold up,
Second, do we have questions?
Yeah, question.
Go ahead, recommend.
It's either gonna be a discussion or a decision.
You can pull something from the floor. I'll make space for that, but I'd like to discuss it first,
Okay, no problem.
if we can.
That's what the question come in at, and we want to make sure that we're being very modest about, moving a motion that could possibly, not protect or,
That's why I want to discuss it. I don't want to clog up this period here. It's 8:45. I don't want to clog up this period here. We can go ahead and
All right, so.
table items 2 through 5 for the April meeting, and then we can move 6 down to discussion and proceed, because that's the very next thing.
Okay, yeah, it's been moving properly
It's
second,
been
right?
moved in second. All in favor, say aye.
Aye.
All opposed? So moved. All right, board discussion, item number 6. Approval of resolution CRA-R 2026-9, nullifying the unauthorized actions of the mayor. Ms. Bellinger, would you read the PM?
Resolution CRAR 2026-9, a resolution of the town of Eatonville Community Development Authority for nullifying any and actions of mayor, both past and present, and demanding full compliance with its directives and providing for conflict, ability, and effectiveness.
You've heard preamble. I'll entertain a motion for approval.
Just for discussion.
I'm sorry.
Yeah, yeah.
We will open it up for discussion. If it's okay, I'll start,
Okay.
because I didn't do too much talking on Monday. Methodology, I do believe, is important. And we do put these policies and procedures into place to remove the appearance of bias. I have my personal opinions about the performance of Director Johnson. However, I do respect this board's authority to discuss his employment Attorney Jackson, thank you for all your emails and all your memos and all your opinions. Again, I do not hold the Juris Doctor, but I respectfully disagree. And I will open up the floor. Me personally, my thought process is that if these actions were so unauthorized, then it almost should not matter. There should be no need for Monday's resolution. There should be no need for implementation if it is null and void. If it is null and void, I am in favor of entertaining a motion to make that decision tonight. But I will yield to the rest of the board members to see how y'all want to move forward.
And, okay, I'm sorry.
And you gotta go last,
Let me
because
say
Aaron,
something.
you didn't talk, nobody else has. Yes.
Anybody else wanna talk?
On the preamble, y'all have mayor, it should be preamble, you have mayor, and it should be former.
Let us be clear, it's been 2 days, not with Chris. Former is fine.
Okay, cool.
No, it's linger. Pardon me,
Past the future. Okay,
we're taking out,
past that, go past that, present.
actions of, we're taking out both.
So you're taking out the action, it should be actions of the form.
Yeah,
Inserting former between of and mayor, removing both past and present.
Yeah.
I'm sorry, Director Williams, did you have a comment? No, okay.
I'm looking for, again, clarification from, Attorney Jackson in terms of the motion that we did
right,
put on the floor on Monday.
right.
Is that clear? And because I do know that, we did receive emails in terms of, Chair, Randolph and Washington. Okay, so from that, what I read from that particular email, I want to just more clarification. I know we've heard it all night long. And because I hate to entertain this motion for it to come back again, that, hey, it still is gonna be nullified. That's my stance. All right, in terms of that, and there was something else that we did receive in the email that basically said that, look, this is not gonna fly in trouble with that. But let's deal with the resignation part, right? Because I don't want us to do this tonight. We already did it Monday night and then have to come back again. You know, if it's gonna be null and void, I need to know like tonight. You know, is it going to fly?
Right.
Or do we need to still, we're discussing it now, or do we need to come back to it? And something else that I learned as well, I think you directed Matt. I do like what you said as well, in terms of if this does pass, will there be opportunity for us, the board, to put in certain parameters for the executive director?
Right.
There's something else that I would like to know, or does the contract that he's under, does that? Okay,
You understand the agreement,
the agreement,
right, the employment terms
yes,
that he's under.
right, so is there room for us to make adjustment, additions, whatever? So those are some questions that I have in terms of reinstating the executive director. Can somebody help me with that?
So I don't know how much clearer Florida statutes can be, and I don't know how much clearer I can be. I understand that people keep saying that these people resigned and they automatically think that because they resigned, that's when their term ended. That is not what Florida statute says with regards to how long or when they give up their role or their position. Florida statute is very clear, and it's not me saying it, it's the statutory provision. It's the statutory provision that has been reviewed by the Office of the Attorney General that certain folks will and also the Attorney General has indicated that a commissioner, just get it again, because I want to make sure that this is clear. Each commissioner shall hold office until his successor has been appointed and has qualified. That's the Florida law cannot be any clearer than that. The Office of the Attorney General has weighed in and has issued an opinion. And when we talk about Attorney General's opinions, they may not be binding authority, but they are persuasive authority. And persuasive authorities can also be used by courts in order to reach decisions that align with the Attorney General's opinion. And again, what the Attorney General has indicated and stated in the resign to run law effective date of resignation, AGO 77-5, the Attorney General, in their opinion, said that the resigned municipal officer may continue to serve until the vacancy for the unexpired term of his office is filled in accordance with procedures provided in municipal charter. So the vacancy happens at the time that they resign, and the time period for them to resign has come and passed. And the AG is very clear that that resigned municipal officer may continue to serve until the vacancy for the unexpired term of his office is filled. As much as people may want to disagree with me, you're really not disagreeing with me, you're disagreeing with Florida law. That's not Attorney Greg Jackson saying it. This is not an opinion that I have crafted myself. It's that a long-standing opinion from the Attorney General's office with regards to the resign to run law. That is very clear. And I can't be any clearer on that. I understand what 99.10.012 says. And this opinion is even in light of 99.012. Because if you read the entire thing, the resignation of an elected municipal officer who resigned pursuant to 99.02 Florida statutes. This is a Florida Attorney General that's making the statement, not Greg Jackson.
Okay, and to my second point, what former Chair Gardner stated, and also Director Matt, our ability to evaluate the executive director as a board.
Right.
All right, and I do understand what she said, that administratively is something that will have to come from the administrative side. And well, obviously, this board has never evaluated the executive director before. If we had, I don't think we'll be here today, right?
This
So-
board or
Yes,
any board?
or any board.
Any board?
Any
Boards
board.
he does have evaluations in his personnel file.
He does.
evaluation.
I don't know what the term is.
So-
No, I mean, from previous, he has not had one since he's been back, but he has, from previous, tenures. He has,
But he should have, at that 6-month period, he should have had an evaluation.
and I don't think that we had agreed upon, even discussed an evaluation. So to your,
So this is something that we need to do. Okay, and I want to make sure that we are able to do that. This is all in lieu of, if we're considering a reinstatement form, I think that we need to come up to speed as to what we need to do. Right? So that's just my opinion. And if that stuff gets cleared up, I'm on board with it. Because we all need to be evaluated as to what we're doing out here. I think we all need to have checks and balances. I don't feel like anybody should be able to just kind of roam free of the land, right? We all need checks and balances and accountability as to what we're doing. And this is to my point, to the residents, I want you guys to know that I hear you. I've heard your concerns, and it is my position, we're gonna do better, y'all. Only thing I ask is that you all bear with us while we kind of get some of these things kind of ironed out. We're gonna do better, right? I have 296 reasons to say, I'm gonna do better. You understand? And I appreciate you guys, but we gonna get it together, y'all. So be patient, please, as we try to move forward in a proper manner. That's my ask to the residents and the citizens of this historic town.
Director Ware Jordan, I see your 296 and I raise you a potential solution to your question. I did consider that as well. I spoke with HR because the evaluations that are in the file seem a bit outdated. We have not as a board discussed what that evaluation looks like since we brought Director Johnson back. The evaluation that was done by the chair, mayor, whatever you want to classify it as, seems to be extremely thorough. If it is amenable to this board, I think we should maybe consider that as a foundation, maybe put some customizations on it, take some things out that we don't want, add some things in that we might like, but it might give us a basis to move forward for that direction. And then we should probably establish some terms as well, like a biannual. We know budget time is coming up, we know merit is coming up. We want to make sure that we have that stuff in place. And if we can line it up parallel, even though we separate but distinct, if we can line it up parallel to what's happening on the town side, that saves us time, money, and administrative responsibilities. And if that's okay with this board, I have a few copies here for us to consider. And again, I think that we can make a decision tonight and return to a potential evaluation in a month, or maybe conduct another meeting. I do remember seeing an email with his 6 month being March 31st or something along that lines. I know that's only in 2 weeks. Don't necessarily care to meet again, but if that's what this board wants, we have at least something to start with. Attorney Jackson.
So, Madam Board Member, I just wanted to point out that it was you, HR, and myself that had this conversation.
Correct.
Because I actually had some recommendations myself as to how to move forward. Because I've heard some of the comments made, and so I've had some recommendations that I did discuss with the board member at that time. And one of the solutions that was discussed is the way that the town clerk is evaluated should be a similar process that the executive director is evaluated. So I just want to make, I want to make clear that it's never been that I thought that if my position, Mr. Johnson, should not have been evaluated. It's always been my position that it should have been done the proper way. And I think that the conversation that we had today was a very beneficial conversation, because you understand that I'm not in disagreement with evaluation. I'm only in disagreement with how evaluation was done. That's it.
So if we're gonna do it the proper way, and when did you say his evaluation was due 6 months?
His 6 month would be March 31st
So the
of this year.
evaluation should be March 31st.
But there should be, what I would suggest is you do a baseline. And that baseline is the 31st. So if there's a new board coming in and establish what criteria you would like at that 31st, and then you do a 6 month evaluation after that, but you have to establish some baseline.
That would be a Tuesday.
But there's no baseline that's been set right now.
And so that's good with me. I mean, I know we probably need to poll it properly.
Well, I'm not saying exactly the 31st. I'm just saying if that's around.
On or before.
If that's.
Whatever they can come up with.
Any opposition? No.
That's fine.
Okay.
Oh, we can't move a motion right now until board member come back.
So in the meantime, I still think that I have never been on that side of that procedure as it pertains to those appointed members, such as the clerk. I don't know what documentation they use for that. I can have Ms. King send that out if this board would like, so that we have that baseline. Unless you guys would like to see, well, you all have seen the evaluation that has been submitted thus far, correct?
Yeah.
The one that Chair
No.
Gardner submitted?
No.
Yeah, but
I'm not-
but at the same time, former director and mayor with direct chair. It's up to this board.
Yeah, so do y'all want the formula that she used, or do you want to start from scratch?
We turn the whole other,
So you want something from Ms. King?
yeah,
Okay.
turn the whole other league.
So if Ms. Bellinger, if we can get a copy of the evaluation form that is used on the town side for those appointed members, emailed out to all the directors.
You can make that determination.
So we can make corrections to what she said.
Right, and then I would encourage that when you get that, take a look at it, and then when we come back that night, we can solidify, we can agree to, and then we can move forward with the evaluation based off what we
So
agree
you
to.
think it's necessary to do a workshop before we actually do the evaluation? Probably be ideal. But I know.
Well, yeah, if y'all wanna do it on the 31st, there is no council meeting that night, we can come 6:30.
And then, well, I can come at 5:30 and then have the actual meeting at 6:30. We'll do the workshop at 5:30, right, to discuss it. You know what I'm saying, make our determination on what we want to do in terms of
5:30.
evaluation, and then we'll go right into the actual meeting at 6:30.
Can we confirm that there's nothing else on the town calendar, just to ensure I don't wanna impede upon any other potential scheduled, Tuesday, March 31st.
To have the town council.
That's the
Oh, that's
fifth
the next
Tuesday,
following
it should be first and third.
Yeah, every first and third Tuesday is,
That's why I said, you don't wanna do 6:30?
what do you wanna do, Chair?
Since we normally do 6:30 on first and third, we can do workshop at 6:30, unless, I'm amenable to 5:30, I'm available.
I'm just saying, though, that way we can discuss it, you know what I'm saying, get a better, get more information on what we need to do to move forward with making our evaluation
5:30?
as a board.
Like 5:30.
Okay,
Yeah,
5:30 Tuesday, March 31st.
Workshop meeting.
Okay, let's, do we wanna poll now?
yeah, it's like this thing.
Director Collins?
Yeah.
I for Director Craig? Board member?
Aye, Director Mack.
Question. So we're meeting to do,
We're meeting to establish,
Review.
review the town's policy for evaluations for individuals such as the clerk.
so
To
the HR
customize,
person will be here to make you.
we'll have HR here, we will confirm if we can get HR here, to walk us through that.
So
and
if
then we-
she's not here, what would be the purpose of having the meeting? Because we're not HR.
No, but what we're gonna do is use the form as a baseline to build and agree upon an evaluation metric that we can measure performance by.
So we got Miss Marissa.
No, I think Attorney Jackson need to be the one in charge of that, of the meeting. Because he can give us any kind of recommendations as we email back and forth our differences or whatever.
Right.
So anything that he may bring to us, cause we're dealing with the total, I'm thinking we're dealing with it.
I'm only referencing that because his suggestion was that we do it the way that they do it on that side. How the appointed member being the clerk,
That's the problem.
there's
Something on their side.
but it would be a baseline, because we don't have anything at all,
Yeah, we get
technically.
information from.
But that would be up to us.
That's why we creating our own,
But what we're saying is, do you want to come together?
we gonna do that.
Yeah, we're gonna sit down as a board to actually
But I don't need no town official telling us how to do what we need to do. Cause that's the problem. That's why we're here today.
I don't think that's gonna be the basic of what we're gonna be.
You know what I mean?
Just a formula. So we can have,
Us a formula.
yeah, we
I
can.
don't need-
That's fine.
We're the decision makers.
We don't have to be.
Yeah, so, but I get what you're saying.
Attorney Jackson, do you have any opposition to guiding us through that process?
I have no opposition. I would recommend, however, that we do have HR here just for that preliminary,
Right.
setting up of.
For the workshop.
Yes.
That's very positive.
But it should still be fair that the directors receive it, review it, send what redlining you have, if you have any questions, to address them to you. Okay, we can do that.
Alright.
5:30, March 31st.
Do we continue the form call? Yeah.
You get home, so
It should
everybody.
be 5.
Short and mad.
There's all 5.
But do me a favor though, could you please email each individual also, just to have it on record and a paper trail on it? We've already confirmed it on the record that we're gonna be there, but just to, notify that we are confirming through email that we're gonna actually be there also.
And for me, since my town email doesn't work, since we some transition, it's okay to use my personal email. If you don't have it, I'll give it to you after me.
So Chair,
So then my question now is there a need to revisit, is there a need to entertain this resolution as it reads? Or is it your general council opinion that the actions that were taken were not authorized, and so there was no technical need for the reinstatement if he was never not instated?
So,
If he was never not, if he was not removed appropriately.
So the only thing I can say, again, is that, the decision made on Monday, is a decision of this board, and that decision should stand. I don't believe that there's any need to do this resolution because the decision of this board has already been fully stated. The only issue now is what happened on the other side. Are they going to respect what this board has dictated that it do? The one concern that I understand that, Councilwoman, Jordan, I want to call you Ware so bad. The one concern I have is that this board, when it makes decisions, becomes a toothless lion. And they say that they want something done, something corrected, and it doesn't get done because people said, well, if we don't do it, nothing's gonna happen anyways. That is my one.
What is your recommendation?
My recommendation is, as it has been from the beginning.
To move forward with Monday's decision.
Yes, ma'am. Respect the board's decision.
That way we eliminate any other resolution that we got in place. Because I think that's what we leaning toward, we could, okay. That, so, that was solely the.
So with the reinstatement, it's with the understanding that we're gonna come back and do an evaluation by this board.
Because he's already gonna be reinstated. And then we're gonna evaluate him on the 31st. And then we'll make another determination on his evaluation. And you know how evaluation goes. He's gonna be evaluated not by only one individual, but this entire board. And he's gonna have opportunity to answer questions that we want to be answered. And he's gonna have to show his scope of work that he's done also to, you know, further tell us if he's doing the job that we need him to do as the executive director. If that makes sense. Derek, you understand?
Oh, I understand. It's still my position that if the actions were unauthorized by the chairwoman, then there was no need for a motion on Monday.
But we gotta.
And if there was a motion and that motion was valid, via quorum, via resign and run, then it should just be implemented.
Yeah, the motion, the vote on Monday was not just to establish that what was done was unauthorized. It was to return certain things, because even though it's been determined, or even though this board determined that it was unauthorized, he still is being called a terminated employee. He still is being denied access to his office. He still doesn't have access to emails. He still doesn't have the vehicle that was assigned to him by the toll. So it was much more than just saying that the acts were unauthorized, because even in saying that they were unauthorized, he is still being treated as if they were authorized. So you can't say they weren't authorized, so there's nothing that we need to do, when everything that is being done is as if it was authorized. So this board has determined that the then mayor did not have the authority to do it, and to reinstate him and to reverse all of the negative things and to expunge his employment file with regards to the evaluation that was in there. Because I don't know if you heard, but even though the evaluation may have seemed thorough, there was misinformation in that evaluation, that where that will now follow this employee for the remainder of his career with this agency, and potentially be a public record that is defamatory in nature. So that is what the vote was not. It was not just to say it was unauthorized. It was to say it was unauthorized. Now reverse all of these things that have taken place, which to this day still has not taken place.
So then there would be no need for another motion. It would just need to be implemented.
Right.
That's
There you go.
exactly.
You just hit
What are
on
we
the nail.
voting on?
Yeah.
Where you going?
Hey, you, wait.
They put this on the agenda. That agenda had 2 items before I got this amendment last night.
So at this time, Count on you, Mayor. Hey, just count on you.
Don't start on me.
We can scratch on you. If we're gonna go do what Attorney Jackson suggested that we do, we can scratch everything else. Everything else can be eliminated. If that makes sense.
I mean, listen, if you have legal authority to go against what everybody said, please provide it. I've been saying that from the beginning.
I don't.
Provide the legal authority.
I do
And
not.
I can understand that people may disagree with me, but it's not about disagreement.
No, it's not.
And then also, Chair, we're gonna be doing the evaluation and we can make our determination
I'm not opposed to that.
at that moment, you know what I'm saying? And it'll totally be up to this board. And then also what troubles me is, that's why I was moving forward, we're trying to get a quorum to have an action meeting to appoint, a chair. I mean, a director and a chair that we need filled. You understand? On top of the other one. So it's 2, positions that we gotta fill. But with that being said, we can't deal with the other one until council.
Either of them, they both council decisions. That the council appoints.
Yeah, that's what I'm saying. So that's why I was trying to actually have an emergency meeting to do that. But neither there or there, you've already said we can implement what we said we was gonna do on Monday, which was approved, right? So that way we ain't even gotta go with everything else that's, down here as a resolution, with number 6 especially, because it's already been established that we're gonna do what we say we're gonna do as a board. We're gonna concur with. But it's already been established by this board that that's something that we wanna do, but we wanna make sure that it's been done though. You know, like, giving him his vehicle back, giving him access to, email, not making his employees uncomfortable, you know what I'm saying? And not thinking that they're gonna have a job, because that's the most uncomfortable position to be in. I don't wanna sit here and, speak too much on that, but I think we just need to, do the right thing. And we already know who that comes from. So there's no need to even discuss anything else concerning that. So Chair,
And so it would just be giving direction tonight administratively to request that those items be implemented. And who has the authority to do that?
Because we fought to reverse it.
To request that what was asked on Monday is honored.
Well, I mean, since it's been said multiple times, you as chair or acting chair, have the authority.
That's the title we're giving tonight.
No, I mean, I'm just saying.
Even authorized.
Yeah, true. Yeah, well, we gotta let the council speak on that. I don't wanna step on the council's stuff.
Likewise,
But what you wanna do is, as the chair, you have to reach out to the administration, and make the administration aware of this board's desires. And as the chair, you have to, as the chair, speaking on behalf of the board, encourage, and demand that they return the TOBRA employee back to his normal staff. That is your role as the chair. It's not a great position because when you talk to that administration, individual, it'll probably be in the morning in the mirror.
might be tonight. Well, we said immediately, effective immediately, that's what we said. And I think that's the, no, but I'm speaking about Monday. But we definitely need to do that effective immediately, like, it need to happen like right now. It has to happen now.
Director Matt is respectfully is 9:15.
I know, but
I
I'm
will make
saying,
the commitment on the record to address that first thing in the morning. Is that okay with you? It's 9:15 at night. I don't think it's appropriate, Bob, that it's late. I think we agree on the direction that we're gonna go forward. If it's okay with this board, I will take the direction to make those concessions first thing in the morning.
all right, that's fine, that's
Okay.
fair, that's fair. Yeah, that's fair.
Okay, so then effectively, we can, do we even need to address the resolution at all for tabling or removing, withdrawing the resolution? Is there a motion necessary for that? I will entertain a motion to remove the approval of resolution CRA-R-2026-9, notifying unauthorized actions of the mayor from the agenda. Do I have a motion?
So moved.
Do I have a second? Good. Been moved in second. All in favor say aye. All opposed?
Nay.
Nay. The ayes have it. Board decisions.
Can you do a roll call for that?
Director Thomas.
No.
Director Creighton is a no. Director Jordan.
Aye.
Director Mack.
Aye.
Director Williams.
Aye.
You have it. Now on to board decisions.
He said we just need to vote on that if you bring it up. Oh, we are.
And this is-
No. This board decision is item number 7.
And
This is something that was added, so before we move forward, I would like to put a motion to table this item. The board was not given this information in a reasonable time to address it. And I know that it's something that's been talked about. I would like for the board to have that opportunity to discuss it prior to making a decision. I will entertain a motion to table until the April meeting. Do I have a motion?
So moved. Second.
It's been moved in second. All in favor say aye.
Aye.
All opposed? The ayes have it. Staff reports. No report?
No report.
Ms. Bellinger,
I do not have it.
did you want to make a report tonight? No. Ms. Bradshaw, do we have any reports from staff? I just want to make the floor open for you in case you need it. Yes.
Actually, I apologize, I would be remiss, with regards to, the item that was tabled, number 7, one of the concerns of, the total executive director is that he has been, precluded from entering the building. And so he wanted this space, so I felt it was necessary to mention why that, item was on the agenda.
Thank you. Thank you. Y'all heard that?
We're implementing everything, so I don't think it matters at this
We
point.
can come back to it. And I will, I haven't had the chance to sit with the executive director, so I'll be sure to get some feedback. I have heard it floating, but I have not had the chance to talk to him, so I'll be glad to sit with him and discuss that further. So thank you for the clarity. Board reports, Director Thomas.
Interesting duty. But, since, we're gonna do an evaluation on the 31st, I wanna make a motion that we, postpone any, projects, financial things until we actually do this evaluation report, because we got to be able to, review these things. And then I did ask for several things. I asked for the balance sheet and the general ledger, because you just gave me bank statements that, I can't make a decision off of. I'm not saying it's false statements, but these look like false numbers to me. So I want to make a motion that we set aside any projects, any financial things until further notice by this board, until we're able to review and evaluate these things.
I think we have fiscal responsibilities that we cannot avoid that will come due before we meet again.
Such as,
The loan repayment, subscriptions that allow administrative operation.
I would say those things, yes, but any other financial, no. I understand what you're saying, but
Ms. Bradshaw, can you please weigh in on? Wow.
what do we have to pay to cover what is?
There are several projects that are in play and work that is being done by vendors. That once they provide us with invoices, we have an obligation to pay them. There's the Club Eden project, and we're not only obligated to the vendor, we've received state funding through the grant. And so we're obligated to meet those requirements. The grant hinges on certain processes being completed within a timely manner. Our loan repayment must be, it is due every month. There are software systems that we use on a regular basis.
Such as?
Our Adobe, our Microsoft, our Zoom, those are all Garcia for the website. We are obligated to pay those individuals once they provide us with services. And those are monthly obligations that are be paid.
So, is the AI and all of those monthly obligations that you have to pay as well? And if that is the case, then I want a history of everything that has been put on that AI. Because if that's the case, you put the CRA business on AI and made it public. So then I would like a copy of I want a copy of the history of everything that has been on that AI.
So for the purpose of your motion,
I understand that we got bills to pay and I expect the bills to be paid, but anything other than that, no, I want it postponed until, this board, me as a new board member, until I'm brought up to the understanding of what's going on, how it's going on, and those type of things.
Me personally, I think the best thing for you to do is to get once he's being reinstated tomorrow, set up an appointment so he can bring you up to speed on everything that you got a question about.
And if you're gonna bring me up to speed, don't bring me up to speed with telling me I want that paperwork in front of me because I want to see it. Everything that you're gonna talk about, that you're gonna do,
ask for
I don't
what
want
you're asking
no
for,
speech.
you
I
still
want
be provided.
paperwork. Exactly.
I agree with you. You know what I'm saying? So you ask for, you're a board member, so
Yeah, you gotta
he
give it to you.
need to give you that.
Yeah, you need to give it to you.
Okay,
But for stopping business and all that stuff.
I'm not stopping business. I'm
You
stopping.
stopping projects.
Am I really?
Yeah, you are.
Okay, well, that's my motion.
I like to weigh in with, board member, Thomas. To a certain extent, I do agree with you, board member, Thomas. I don't want to stop progress. No, not at all. We gotta pay the bills, understandable. But you help me, board member Thomas, if I'm wrong. But in terms of our projects or new projects, I too, I see a lot of signs around town that things that we're gonna do. And you help me too, board member Thomas, but where are we? I'd like to come up to speed, me too, just like you said, maybe I need to catch up with him and have a meeting with him as well. What are we doing? Where are we? What are the finances? I know we got about 8 different projects that appear to be ongoing. I've seen several signs around town. So I would like to actually be brought up to speed. I know it's not this speed, right? And I think we all deserve that, right? And I'm speaking for myself, the community, the residents. Bring us all up to speed. Things have to be done more transparent and accountable, right? Pay the bills, please pay bills.
Yes. Yeah, I'm saying pay the bills, but
Please pay.
as far as, there are board members that have been here.
Yeah.
So you don't have to just meet with me or that one individual. Bring it to us in front of us so that all of us know at the same time exactly what's going on. I'm not saying give me an individual meeting. I'm saying.
I've been here as well, Board Member Thomas, but I've probably only had one meeting, 2 times. You know, and that's just, I'm just speaking for myself, y'all.
if it's okay,
So, please.
I think in a
if
nutshell.
it's okay
Go ahead.
with Ms. Thomas, I'm sorry, Director
She
Thomas.
can, no disrespect to you. You can get up here and you can talk and you tell me a whole lot of things. That's not what I want to hear. I want paperwork. I want to see and I want to read for myself. No disrespect to you, but I really don't want to hear what you have to say unless you got that paper in front of me. Because I can read, but if I don't understand it, then I'm gonna come back to you and then I'll ask you. But otherwise, that's my motion and that's just how I am.
Okay, so let's entertain the motion. Let's follow the process and then come to discussion. There's a motion on the floor to suspend any unnecessary spending by the agency until the finances are thoroughly reviewed.
And the projects until we are brought up to date, this board, with each and every project. And I'm not saying stop it with the vendors if that's what you got going, but you have to know that you have to bring this up to us. So if he's coming back, then he has time to call a meeting and say, hey, let's get together, let's do this.
So the motion has been moved. Is there a second?
I second
I
that.
got a question.
Been moved in second, Director Matt.
Listen, let's be mindful. Mr. Johnson worked for this board, okay? Let's make that clear. Whatever we tell him we want and what we need him to do, he gotta do it. Or we will put a motion on the floor to get rid of him. So let's think about that. And then you gotta also think too, I agree with you having him come up here publicly and put it on record, that's fine. But what I tend to do is have meetings with him subject to things that I'm not aware of, that I'm ignorant on, where I can get a better understanding. You understand me? And that's what he got the open door policy for. That's why he's here. He's the executive director for us to go with him at anything. And you gotta understand, we put him in this position to do things, to bring projects to the community. You know what I'm saying?
But Director Mac, my point is this right here. Yeah, I'm new, and we're gonna bring in 2 other new members, y'all. So like, let's just,
But listen to what I'm saying though.
yes, sir.
Now you guys sitting here talking about freezing particular things. What are we talking about in particular though? Like we're saying freezing things, but if we're freezing things, and like you just heard from the accountant for the CRA, we got bills to pay also.
No,
we don't want to put ourselves in a situation.
Pay the
to-
bills, pay the bills.
But
You know what they got.
But what though?
I'm just.
But what that look like though?
I'm
What does that look like though?
In terms of the projects that are out there, please just count, let us know.
Know what's going on.
Pay the bill.
But we don't need to freeze anything because you can freeze something that could be an obligation for us to pay.
But that's
Let's
what we
yield back
said,
to-
if he has to pay.
So why you put a?
Let's yield. Let's yield. I know we're ready to go. Let's yield. Please.
Yeah, she's the financial guru. She know what bills are.
We are yielding. We are yielding.
Yes, ma'am.
Ms. Thomas, please.
I made my
Director Thomas.
motion and it is what it is.
The motion has been moved. It has been seconded. All in favor, say aye.
Aye.
All opposed?
Nay.
Nay. Can we get a roll call, please?
Director Thomas.
Aye.
Director Jordan.
Aye.
Director Matt.
Aye.
Director Williams.
Nay.
Director Kern.
Nay.
You said later.
Freeze or no? Freeze or no?
I don't want to freeze.
No free, then it's nay. Nay. Okay, so nay. What do we have? 3-2, nay? The motion fails. Ms. Thomas, we can sit, I can't sit with you. Ms. Bradshaw, Ms. Jones, Ms. Henson, can we get some documentation for Director Thomas as well as Director Jordan, for all the directors to review and then potentially bring it back for the March 31st meeting?
Perfectly fine, and I prefer mine to be printed. I don't want no email. You can send it in email, but I still want mine printed.
I mean, I have some public records requests, and it is, I wanna make sure I'm providing her what she wants. I don't wanna send her something and then it's not the documentation that she's looking for.
Did you have anything else in your report?
No, ma'am.
Okay. Director Williams?
One thing I have to say, being a part of this community for 50+ years, the town that Freedom built, that's what we stand on. I grew up in this community. We had our own fire department. We had a garbage truck. You know, we had we were self-sufficient. Now we fast forward many years, later, we got the highest tax millage rate in Orange County and the worst services. That's not a CRA problem, that's a town problem. But for citizens to come up here and want to build out the CRA, you need to check the other side first before you come to this side. The only thing we've been trying to do is move forward. But every time we try to move, we come to this foolishness. Always town opposition to why we can't do things, why the things look where they are. But we have done something. You got a gateway, we did a streetscape more than one time, you got a library. That was all called the CRA. There's some other thing we would like to do, but that I've been wanting to do, but it's always been town interference. Let me just say it like that. If you go back into the history of what's been done with the CRA, and what been cost of the executive director, it was other thing that was going on. All right, until we learn to be as a whole community servant and not self-serving, hey, we'll be better off. We got to be community servant. It's been time before, I just felt like that we were self-serving. That's why we got nothing. That's why the town is in the shape the way it is now. But we got to come together as a community to go forward. Stop putting things in reverse. Stop putting in part. All right. At the end of the day, people talk about my kids, all this stuff living in this community. I get that. All right, but it's up to us to lay that foundation so they have something to come to safely. All right, because everybody know it don't matter what street you go, you're gonna hit a pothole. Well, once again, that's a town problem. All right, so the town got to do better so we can be better. That's my obligation. I'm gonna say we need to work together. All this going back and forth, people being misinformed. Come on, man. The attorney set up here gave you the facts. Yeah. Y'all, when we want to go against the fact, we want to go the extra mile and do our own homework, which I don't mind. You, that's your opinion. But at the end of the day, we got facts. Let's move on to facts, not opinions. We got facts. If you can't make an informed decision on the facts that's given, hey, look at me. Are you being true to yourself? Are you being true to this community? That's my report.
Director Matt?
Yeah, I know, say guys, listen, I appreciate you guys coming out being engaged and see our business. I think it's extremely important that we come in here, voice our opinion, because whether I agree with you, don't agree with you, or indifferent, man, I still value you. You know what I'm saying, as a resident, as a citizen in this community. And I do take everything into consideration that you do say, but I gotta make the best educated decision up here, as a director also. But with that being said, I didn't get the opportunity to say it on Tuesday night, so I'm gonna say it now, man, listen. Happy International Women's Month, I think it's extremely important that, we have women. God said, when He created man, man should be alone. So I value every woman, especially my mom, my wife, my sister, cousins, nieces. Um, they're so instrumental, in my life and inspiring in my life, just as well as every woman up here that I sit with. You know what I'm saying? I respect you. I respect every woman. It don't matter who you are. You guys are really doing things to empower yourself because I know how hard it was for you in the, later days that we had, just coming up in this, nation that we live in. So, kudos to y'all, salute to every woman that we have in this nation and that we have in this room especially. And also congratulations to all the members that sit on this board now. I think we're gonna do some things that's gonna be, inspirational for the community. And just remember, man, this entire time is covered by the CRA. And it's time for us to make history and do something that's gonna be impeccable. You know what I'm saying? We haven't turned any dirt in this community in years. You know what I'm saying? I heard it all night, 29 years. That's pretty significant. You know what I'm saying? And we need to, just, get in a very profound position to do something that's gonna be inspirational, not only for our kids, but our kids. Because it's up to us. You know what I'm saying? We're the trendsetters in this community. We're the ones that make the decisions based off of just sitting up here. We have the power. We have the authority to do things in this community as council members and as board members. So let's make sure that we're moving forward with doing those things right there. Also, I'm glad we're in a position to bring Mr. Johnson back and reinstatement while we can get some things done. And if you do feel like the need to go in there and speak with him regarding anything, he have an open door policy, man. He worked for us. He worked for this board. We don't work for him. He worked for us. And we work for the people. So we got to make sure that we're being diligent and moving forward, doing all the things necessary to push this town forward and making sure that we're successful, And Mr. Attorney Jackson, I appreciate you with just the professionalism that you bring to this board. I thank you for all your expertise that you bring to this board as a lawyer. I'm not an attorney either, but I'm not a fool. I can tell you that. And it's gonna be times where I don't agree with you, because I have not agreed with you on a lot of times that you discuss some things, but in this particular situation, I strongly agree with you because the evidence is proof. It's there. And anybody that is an attorney can tell you that the proof is there. You know what I'm saying? Based off not only the AG, which is not law, but just the bylaws itself and then the Florida statute within the guidelines of that. So thank you for everything that you do, and then you're still in this board and protecting us. Thank you. And that's my report.
Director Thornton.
All right, thank you guys, residents, community, everybody for coming out. Attorney Jackson, I really do appreciate you and, I like the way that you break things down, so thank you very much. And also the other directors, and I just ask if for myself, please be patient. I'm a person, I like to get understanding and I like to get clarity, and I probably ask over and over again, right? Until I get it, until I'm able to make a sound decision and I can sleep with it. You understand what I'm saying? I like to sleep with both eyes closed. So that stuff is important to me. But with that being said, again, just thank you guys and looking forward to just moving forward. I appreciate you.
I'll try to keep this brief. It's been said on a number of occasions that the production of documents the day of is grossly irresponsible. To ask us as directors to make decisions on spot that affect the entire community is unfair. However, I do want to acknowledge the unusual circumstances that staff has had to deal with this week. But if we can get a commitment or a working relationship moving forward to provide documentation as soon as possible, as soon as humanly possible, or to hold items off until the next meeting, or to schedule some time to sit down as a board, special meeting if that's necessary, because I know some things are time sensitive. Maybe we get them when y'all get them. And so I want to be sensitive to that. But 7 o'clock the night before, with 4 to 5 items of great significance that we were not prepared to discuss is a little unfair. To be completely honest with you, I was ready to call for the canceling of today's meeting based off the agenda that we had been provided originally. There were only 2 items that could have potentially waited, so we could have saved an evening. However, I'm still appreciative for the preparation of the amended agenda. So I want to acknowledge staff for that. But I know that it is the wishes of this board, of former board members, of public members to have that documentation as soon as possible to give us ample time to review, to do our due diligence, to do our research, to call, to ask questions, so that we can make responsible decisions. I also want to address working together. I've been up here with at least Director Mack. Oh, you're the only one I've been up here with that long. Oh, and Director Williams for at least 2 years. And I think my record speaks for itself. Again, like I said, I've never been one to buck a conversation, and I am about the people's business. So don't let anybody tell y'all that I'm not working with you or that I am your opposition, because we're equal up here. If you believe half of what you hear, I believe half of what I hear. Okay? Ruth is here for y'all. As it pertains to some public comments that were made, Mr. Novak, I know you mentioned Rose and Brito. Don't quote me on a specific date. There are some continued services that we have with them for architectural business, for rehabilitation, that we should be able to get you some documentation to support. I've made note of that, and I will see to it that you get that information to justify those concerns that you had. Additionally, I believe, and Ms. Bradshaw, you can correct me if I'm wrong, Classic Homes was a recipient of the demolition program grant that supports redevelopment in the community by allowing individuals to request funds to demo blighted and dilapidated structures, just so that there's some justification. I can't give you Chipotle. I didn't get any. However, that information is public record. You should have access to that. And I think it is understood on this board that sometimes justification beats imagination, or documentation beats conversation. So thank you for bringing those to our attention. I think you sparked something very loud in Director Thomas in wanting to review those. Again, for those new directors who might want a more in-depth look, I think it's worth working with staff to get some understanding moving forward. Man, I thought y'all was gonna let me have it. I mean, y'all gave me an hour on Tuesday, and it's been 3 tonight. I move for adjournment.
So moved.
It's been moved in second. All in favor, say aye. Opposed? The time is 9:39. We are adjourned.
Sorry. Hey,